You please give the slips because I came late. You please give the slips. I will fix date. All others you are mentioning for dates, please give the slips. What is the new case?
Yes, new case. Yesterday, was the today, the standing up the disposition. And the whole response is very important. Yesterday, system report response.
Inform the GP.
And inform the report response standing up with the security.
Yes. Yes, madam.
For the petitioner, the admission is pending since 2000.
Private respondent is there, only government is there. Yes. The last time was, why can't you get the file and verify? There is no private respondent, it will come tomorrow. Please give this.
Old lady, 20 years old lady. State and vacated by referring back again to special business.
Tomorrow.
Despite being out of the civil court, government collector tomorrow, so transaction have been floated.
Accepting lunch motion, please don't mention.
Lunch motion.
New cases.
Urgent for instruction of the Lord.
So that is a new case.
Also, we should say that is linked to notice of MRO collector about the to Dharani.
Tomorrow. Civil supplies for being mentioned. Tomorrow.
IFR modification where it's not a survey and one is the government and 87 is the part. And the Pata and father sentence to check.
Better. This case is very and moreover, the filing again and again.
I have asked you to file counter.
Yes, I'll file the complete petition.
Yes, please. Madam, these slips are there. I'll fix date. Please give. I will get it in next 5 working days.
Page number 1, item 1 to 18. Page number 2, item 19 to 33. Page number 3,
item 56 and 69, Your Lordship. Yesterday's matter may be taken up at 2:30, Your Lordship. For the last several days, it was not reaching 56 and 69, Your Lordship.
56 and?
Urgent, Your Lordship. Raidband amount stopped all of a sudden. Item 56 and 69, yesterday's matter.
56 is connected to 69.
Yes, Your Lordship.
Yes, 230.
56, 230. Much obliged, Your Lordship.
38.
Already
71 item alert.
57.
So item number 59,
71 item alert.
Today I have one matter. Here comes the appearing. After that, if I have time, I will get the final.
67.
67. It will reach so many mentions. Wait, it will reach. I don't have.
71 item alert. As your lordship aware, I filed wakalat last occasion and my name is appeared. And your lordship direct me to file an application not to immediately try to save 12 respondents because there is impersonation and fraud is played. And your lordship directed me, I filed them along with an earlier wakalat is returned. My name is not printed and the application millet they have not taken. It is kept pending with the registry. 71 item.
Give the SR number.
Yes, millet. SR number is 106915. 106915 of 23. That is wakalat millet.
Page number 5, item 6272. Page number 6, item 73 to 87. Page number 6.
Yes.
Yes.
Page number 7, item 88 to 105.
From where?
Item number 100 and 106. After 230 management, please. 230,
Item number,
100 and 106.
both are connected.
No, they're different cases. Not connected, different cases.
All your cases are important.
Very, very important matters. All still pending 10
Only
more
your
than 10
cases.
years. More than 10 years, madam. Will be time having here and reach not, my number is not reaching another for
Only your cases are urgent.
Then not this is properties matter, not Dharmi portal up to 4.20.
Choose one case, whichever is urgent.
First 100 is important. 100. Item number 100.
Yes, inform the other side.
Sublet. Item number 102.
Yes.
230.
GP Forest has to come.
Yes, ma'am. I inform. Item 91, ma'am.
104,
Post before another bench.
goes before another bench.
Item 91, ma'am.
71, who is mentioned, Mr. Satya, please.
Amendment of PM, ma'am.
Get the standing council.
Item 91. 230.
Yes.
Survey 101.
Why I have adjourned the survey matter?
That day, mistake of finding not relevant.
Yes.
Item 99, senior citizen matter pertaining to not speaking about inappropriate matters. Was particular instructions. Item 99.
Yes.
Page number 8, item 106 to 109.
Item 40.
Heard in part yesterday or also, where senior person is under of subject. Taken up at.
Yes.
Well.
Lordship may make one submission. 49 extension of interim order, my lord, kindly it can be extended. 49, my lord.
49, let it reach. If it is not
The
reaching,
extension of interim order, my lord. I will wait.
GP has to give an opportunity to oppose the application. If he is not having objection, I will extend.
I will.
49, GP for revenue. There is revenue AGP. Let him come. I will extend.
Yes, my lord. I will wait, my lord.
Page number 9, item 110 to 116. Page number 10, item 117 to 127.
My lord, I am representing Mr. Harisidhar in this matter, my lord. I have been informed that the Tahsildar and the Gram Panchayat have to file counters in this matter. They have not yet filed counters in this matter, my lord.
I'm affected party. When the officials filed in the software doesn't tell us, I filed vacate stay. And the person.
My lord, without affecting partition, only because his name was there, my lord, in the revenue records, he has filed for an application for land conversion use.
Let it come. After hearing, if I am of the opinion counter is required, I'll ask them to come.
Yes.
Let it come.
124 million. Milord, 124 million. Demarcation adequate to the community.
Which one?
What
Yes, I have noted.
124. 124. 233.
Next Tuesday.
Item number
89. I'll take up next Tuesday.
F line, why did I adjourn, madam? Which area? Koppalgoda. Yes, what do you say?
But we don't have park.
In the city outskirts, madam, I have decided within 10-20 kilometers. Beyond city, I can understand. If father's name or grandfather's name is there, I can direct them to conduct exam. Within city, Koppalgoda, you know what is the value? Not for any other reason. Not concerned about the value. Most of the properties have been converted to plots. 50-60 story buildings are coming up, and people are asking for mutation and demarcation. That is the reason I am asking the GP to get instructions. So one person, I don't know whether he is maybe your senior's client. He has asked for survey of 500 acres in Shamshabad, which includes airport also. So if he blindly pass orders, tomorrow airport, and if I pass order, is it possible for survey? If that man does not have interest in the matter, 20 years back it was acquired for airport. He is asking for survey. I am noting down, let him get instructions. So he is saying by default it should be posted after November. Election results will be declared on 4th. 5th. The request of Narayan.
Allotted by the government. Petitioner has obtained tomorrow from this number 4.
Tomorrow.
Number 1, motion list. For judgment cancel, item
Your
1.
Lordship, small mention, just for pronouncement of orders, Your Lordship. Already reserved for orders, Your Lordship. Just a mention.
Keep the number. How did that?
WP 37146 of 2022.
Why did your AGP make a request in this case again in item number 1? You wanted to file additional documents in this case?
Already filed additional document. That's also done by additional document signed.
Let it be passed.
Very well.
Lordship, WP number may be noted. My apology if I'm interrupting you.
Please give.
WP number 37146 of 2022.
Yes.
Highly obliged. Highly obliged.
Connected to item 1. D6.
Same matter. Then there also petitioners are the same. That's the same would apply. Right.
I think there was some confusion. I pass judgment. Your colleague mentioned some other matter. Somehow I thought mistook it. Mentioning was made in this matter. I'll go through it.
Item 2, Mohammed Quran Pasha.
The respondent not allowing the petitioner person allowed to take basis of the slot participate as subject land on the ground of.
Now for mutation and registration, it is simultaneous slot booking. Simultaneous. So you say it is.
After registration, not they will give the passport.
The ground of court case. Court was filed in the year 2004.
On the ground of court cases, he is not entertaining.
Suit already dismissed last year. Appeal was filed against the suit.
GP shall get instruction.
Not case 12, already pretty.
I will direct them to consider if there is no court stay.
Yes, no, already petitioner filed that petition and also obtained order not taking judgment order to consider. So page 13, page 12. Page 12 on order.
In the directions issued by Honorable Justice Lakshman, did it cover what is happening when they book a slot? If they come to know that there is a court stay,
Yes, yes.
they should know in which case stay was granted. What sort of software is that?
But petitioner has already applied for
In the transaction status, we are saying court stay, but where are the details of the case? Who is the software provider? You do one thing, instead of MLA, RDO, now we should ask the software provider to come to the court. I will ask him to modify. You will never implement that order. I will ask him. Did you do research on ROR Act 1971? Or when he digitized the revenue records in 2018?
This is granted in the year 2005 also.
In Pahani, in mutation proceedings, on the last column, in the remarks, you will know proceeding number. How will you know? In this learning, tell me. He will book a slot. He will pay sale consideration to the vendor. He will go there. You collect the stamp duty registration charges. You will inform him at the time of registration there is court stay. How will you know court stay? 10 days in advance, if his lawyer or whoever is helping him in registration, they verify the records. They find so and so quoted. He will go and verify. And if the suit is disposed of, partition suit as mentioned by him, he will go and inform the MRO and district collector, remove this entry. You are not giving that facility. Digitization should make the life easy, not complicated.
Now also the same thing is going to order. Once there is court case.
Why have you not modified when the directions were issued?
It will be blocked, my lord, until unless unblocked.
I said, they will not block it. We should know the details why it is blocked.
In the year 2017.
You should know today he is deprived of interim order because I do not know for which case stay is granted. Because of injunction in partition suit in OS 141 of 2005, if they have blocked the entry, how will I know? How will I pass interim order today? GP shall get instructions by next date of hearing, 16th motion.
Item 3, Mr. B. Ramakrishna Reddy.
Respondent Tahsildar is claiming error. But the expended instead of 39 because coming part of certain number 50 of August can be made.
far as petitioners are concerned, they are claiming that they are the owners of the lands. Circle number 23 of the letter, the adjacent village.
What you remove the signboard,
Yes,
EP.
I'll take it.
well, sir, just invite the Lord's kind attention to the map I provided, a combined map of shows 2 villages. It is 170 feet. Very good.
Government thinks that by erecting a signboard, they can prove their possession of the property. When you know private parties are in possession of property, you should erect fence. Just like protecting water bodies, protect your lands also. One night you come and keep the signboard there.
Kindly, sir, but signboard also it is not from the target. On that day only it has been, it's the old signboards. Kindly signboard,
Different area.
Will signboard determine your ownership or fencing of land?
That not they have erected, my lord, but it shows the old signboards, my lord, page 211. And the affidavit said that, my lord, we have interpreted and erected the signboards.
Before that,
My lord, kindly see, my lord, 211.
on one. Last name letter, you kindly go through this map like page 173. That would make everything clear. There is no counter interest as against each parties. Admittedly, whether the Tahsildar is claiming it is survey number 50 of Hadastadi village. And our lands are situated in Chidar village. There is no dispute so far as that is concerned. Kindly see that survey number 50 and 253. 253 is on the road.
Let him get instructions. Where is this area? Nature Malkar. I will grant status quo till next date of hearing.
You see, item 4, Mr. Srinivas Rao.
Because petitioner's father is the owner of 10 acres land extent, 5 survey numbers lost. And he passed away in 2015. And succession was given only in respect of 2 survey numbers, and remaining 3 were not given. The application was.
Gambhir Rao, son of Allah Reddy, father of petitioner, was Pattedar.
Yes. And they rejected succession.
Alienated land to one Hanuman Reddy. You see, why are you not making Hanuman Reddy party?
Let me explain one thing. First I made an application for succession. They rejected my application. I filed an expedition here. This court directed them to conduct an inquiry and then pass order. I went on 1st April for the inquiry. Nothing was done. I gave all my papers that my father will know. In fact, Joint Additional Collector, he asked only one question. Are you a Reddy or no? I said, I am Reddy.
How?
I'll come to the point.
How? No.
I'll explain.
Rao is Reddy. Rao is son of Reddy.
So there are instances.
What is the mystery? Mother is a Rao.
There is nothing mystery about it. It's there, villages, they have certain instances of that, there's nothing new. I also inquired.
No, nothing to do with the name. Don't take my statement seriously.
So what happened, after that inquiry, they passed this impugned order.
This Hanuman Reddy party, let him come.
Yes. After that, they didn't give me what is that reference, who it is. I made an RTA application, I got what is that Sada Bainama. 1997 Sada Bainama. My father passed away in 2015.
He alienated the land to one.
I tried the Sada.
So his father's name also same your father's name.
I find Sada Bainama again. The document, it has come be ready. And it is 97 Sada Bainama, my lord. 2015, my father was alive.
To simple say leave in the name of Hanuman Reddy, son of Mallari.
No mutation proceedings, nothing, title is not transferred. My father's name continues.
That is precisely the reason you make him party Hanuman Reddy, that will decide the dispute here. Why you want to contest in the absence of this person?
I don't know who he is.
Who he is means you have to find out, you have to exercise due diligence, that is your duty.
Lordships, in the position column having name, there is no position column now.
Status quo obtaining as on today shall be made. Why, if third party interest is there without hearing him, I am granting interim order, make him party. I'll say status quo with regard to revenue entrance will be made.
Status quo is in my father's name only. The land still continues in my father's name.
Then take advantage of that order.
They are not giving me succession.
Succession, I have to allow the writ petition. It cannot be by way of interim order.
Yes. But
Status quo with regard. Should have what I am doing. Tahsildar should have directed you to do. Collector or Tahsildar. He should have directed you to impeach that person.
in fact, in previous petition, the order was the lordship was
Mr. Srinivas Rao, when a court or judicial authority is hearing a matter, they find some technical problem. They find this Hanuman Reddy was recorded as Patadar in Panis and your father, according to him, sold the land. He should have informed you, make him party. It is not like a court.
yes, my lord, in the previous petition, that was the direction. But he didn't call in for the inquiry at all.
Why will forget about it? Why have you not made him party?
See, the second round of petition, after seeing that he doesn't have title, my father's name.
I can take tuition yesterday, daily I don't mind. I feel I am taking tuition classes, so for youngsters I will take classes. But for a senior like you, do you think I should take classes?
It's not the case, but on my simple case in the current, there is no procedure.
Don't repeat the same point. In first round of litigation, when you know this person is the owner of the
I
property,
didn't know. I didn't know he was the owner. After the
one example I have given in the previous case. Suppose he wants to find name of person. Today he cannot go and apply for Pani or mutation. So this Hanuman Reddy's name is there. How will he find out?
name is not in that list.
By digitizing the revenue records, you are isolating public. They cannot have physical contact with the MROs and collectors. How will you know details of Hanuman Reddy? Give some solution.
His name is not in the records at all. It's only just observation.
Whether he is alive or not.
petitioners will not be possession or not be.
That's why I am asking.
The inquiry in progress.
So and so,
On possession or not will be.
or his family members. (2311) motion.
Item 5, Dr. Krishna.
Petitioners were allotted the
When the Google, Mr. Srinivas Rao, in your presence, I want to ask the GP. When the Google map, it will give
yes, that the petitioners were allotted the house sites.
direct the petitioners to enter into house sites.
Petitioners were allotted.
First time I am seeing this prayer, interim relief. You want to enter into the
Government
property.
of Andhra Pradesh allotted the house flats.
You are already disposed, consequently direct the respondents to allow the petitioners to enter into. You should say deliver back position.
Already they are in the possession outside, or demolished by the government.
Then
Already
why are you
possession
asking
certificate was there.
Permit them to leave. Why it was demolished?
To eliminate some other particulars, we have paid 1,000 rupees in 1999 as a beneficial share. These are the government land. The government acquired the land. Yes, sir. Acquired it with the other party.
How can I grant order when you are disposed and structures raised by you were demolished? How can I grant? You are admitting if you have any semblance of right and possession over the property, I would have granted interim order. You yourself are saying that you are dispossession.
This land was acquired by the government by paying the.
When you are not in possession of the property, how can I grant interim order? Let him get instructions. Next.
GP for assignment. Printed.
Continue was GP assigned.
Item 6, Mr. Vijay Prashant.
Next will be by the petitioner. Next of the. That's important. Notification of the increase. This is the title of page number 16. Of my basic cover. On the basis of my recommendation and revenue records are verifying and addressed a letter to the RDO for issuing an essay order that is on 28/4/2021. This was the subject. Abdul Karim the petitioner. Because 38 of the request. Clearly stated what is the violation for the signing. Because of all the entries from third party names are there.
Restoration of assignment.
Already in position, the names for the names of third party is entered into the revenue record. Mohammed Abul, with no concern. And even that person taking advantage is trying to give last two. They will write it clear to our verification matter.
GP.
This is a simple issue of the audio. In spite of the.
Earlier paragraph, it is stated that POT Act would issued a form 1 and form 2 has been issued. In response to that notice, was submitted petition along with the.
Who is the petitioner?
It is the same.
Karim.
Submitted petition along with the document, the same has been verified, it is found that the assignment cannot be transferable. Accordingly, the same has been resumed from Abid. POT looks to an action take at the state.
Let him get instruction. level motion.
GP plus and
Then you GP falls and PS motion.
Item 7, Mr. Anirudh.
Page number 16 Your Lordship. Only particular for 17 page number.
At least during the election period, why can't you give some grace time to the respondent revenue official? All of you know, for 1 month, nothing will happen. For September, 18th September, you file application and you are coming. Exclude this 1 month until 30th November. Before expiry of 45 days, all of you are coming to the court. Your father's name.
Item 8, Mr. C.S. Kumar.
Plan to assign land to legally obtained for the construction of double bedroom house. We have approached this council court. The order is at page number 4.
Page number?
40. Authorities were directed to either provide us alternate land or provide compensation. On the assurance-
Same parties approached this court earlier. Then
In spite of this note, the authorities initially assured us that they provide us double bedroom housing. But now after the construction is completed, now that the allotment is being done, now they deny us providing.
were you directed to be given preferential allotment instead of allotment by lots?
The direction was that must provide us alternate land or compensation. Court's direction.
43 page.
The authorities assured us that we will be provided one double bedroom house. On that assurance, we have permitted them to construct the house in our lands. The lordship order for the representation that we are giving.
when detailed order was passed by learned judge, why your clients have not taken care to see that another direction is issued when there is an admission that it is your land which is utilized for construction of 2 BHK.
Problem is that they are uneducated and they were assured that they will be given house. The representation.
No, madam, why the council has not requested that order also to be, direction to be included so that you are given 2 BHK on preference.
That was a subsequent suggestion by the authorities. The authorities, when they went on constructing the houses in our land only, they assured by oral, page number 18 is my representation. Where I detailedly written the of the
At least you should have asked for modification of that order. Because it is your land.
number 18.
There should be.
Page 43, madam.
I have passed orders in similar cases.
No, madam, but 43 page number kindly see, madam. Before that, madam, kindly see page number 43.
Yes.
Madam, it is stated that, madam, to the extent of 452 acres. Whether the land which was going to be construction will fall within the petitioner's land or not, madam. For that, madam, they have asked them to conduct an inquiry and to directed them to appear on 26/9/2017. If such land falls in the petitioner's land, madam, then, madam, there was a direction to
Get instruction.
yes, madam.
Not my only request.
Have you submitted representation?
Submitted representation since 2020. Now at page number 18.
Why 20? Why not 2017?
But page number 18 is my latest representation.
And also direction to go on with the further construction.
I only request let them consider my representation.
No, let him find out what happened in 2017 because the learned judge has fixed a date of inquiry.
But let me suggest what if I can be allowed to suggest. On that day, the authorities have assured us that they will give us double bedroom house.
I'll get instructions.
The inspection did not happen.
I am passing an innocuous order. Let them consider representation.
Again, madam, since 2017, madam, they are waiting.
Madam,
Now again, madam.
why can't you wait for a better order?
Yes.
Why you want an order and already your interests are protected by previous order?
I was not protected.
And also direction, madam, go on with the further construction if the petitioners are not found, madam.
The lordship observed the house after
No, madam.
construction, if that is the case, the lordship vacate that order.
Which area? How many 2 BHK are, how many 2 BHK are constructed?
But there are more than two.
Peddagunda,
The Gundawal,
Gundavalli village, Dubbaka mandal. How many?
more than 300 to 400 families. are there.
You should say the number of 2 BHK, then I will grant interim order.
The number of 2 BHK is 1 per petitioner, or 3 B.
How many are constructed in that village as of now?
Exact number or not.
Exact
The lordship may pass over, I think.
Because it's suppose 300 beneficiaries are there. 200 are constructed. I can assume by lots 2 or 3%, it will not make much difference.
All the houses are constructed and it is ready for allotment. And I stated in my representation also, all the construction is completely over.
But since we did not take the precautions to submit application or some written undertaking in the year 2017, you are now merely saying, I was given oral assurance that I will be given preferential allotment. After how many years you are coming to this court? After 6 years.
Believe the words of the only, they are uneducated farmers. That's my only request. The lordship may observe the that the non-GP gets instructions from the lordship should be to vacate the order.
Allotment also we do not know, yes.
I
1
will
week,
instructions,
let them get instructions. 1 week I'll GP 610 get instructions. Yes, post on.
1 week.
15, 16, yes, 16, 11, it will not make much difference, 16, 11.
Item 9, Mr. E. Ravindra Reddy.
Issuance of,
Issuance of death certificate.
for death certificate, people are coming to the court. Huh?
Given.
91.
91.
Death is also disputed.
But they say that immediately they are not compliant. What was the reason?
It is not registered under Births and Deaths Act, they have to conduct inquiry. TSHC step.
At that time, Mr. Guruma Sudanati.
Government is appointed to create around and now it is known as page number 12 and the award will not be any disputation done but it take a page number 12.
This story of journey of
Page number 12 allowed.
Why? In the record, I saw my, let's say, get instruction.
Item 11, Mr. Venkateswar Rao. The petition for electing this community 5 acres of land.
For survey, why did you write such a big history of your case?
This related the entire title also. Tomorrow, if the private parties are there,
Private parties are there.
therefore, they may. Put on.
Since private parties are there, let them come.
No, actually, they are already notice has been issued. But it's notice. Page number 165.
Which, see, you want a restraint order, notice to rest. Law and order issue, let me find out. I will bind over the parties. If they engage lawyers here, that is better for you. I will bind over them. 2311 motion. Register is.
Control Nathan Reddy.
But in respect of some transactions seem to have been initiated by some third party without any notice to me. Similar to that overall with that, but this is a different grant totally. Thank you.
Another party is saying, headlines are with another party, because
They are coming here, saying that they have got interest in the property.
I will be asking status code to be. In the mean, its transaction status says somebody is initiated transaction. I have one stance only that page number 90 was definitely issued. With that.
1 minute, 1 minute. What is your survey number?
Page 500, page 20, go to Joshua Sessi for a minute.
Survey number is same.
But my name is there, not only the.
697 by 1.
698, then page 23 is 698, page 24 is 697 by 1. Both of these, Joshua may see the name of the Patedar, we run around. Page 23, Patedar 698, we run around. Bottom of the page says ongoing transaction. I have not done that transaction. Next page, 697, we run around, ongoing transaction. I have not done that transaction. But from my name, third party's name cannot be given under that. They say I have executed a deed. And there is a status quo in respect of entry by way of a writ petition. But it is page 167 and 5.
yeah, he is aware of all these proceedings. He is aware that
The proceedings are being checked.
And also in upgrade in the suits are disputed there.
Rangarao's mutation was set aside for his
Page one.
Mutation was sanctioned in 2014.
Page 167.
That was continued till now, the second quarter.
Page 167, approximately for a minute. Page 167. Status quo has to increase is there for this honorable court since 2014. Passbooks are in my name, mutation is in my name. Without my transaction, they say that they will do this. 167. Page 13th October 2014, V. Rangarao versus so. Losses received. However, in the meantime, no fresh entries in the revenue records to be made pursuant to the interim order. Now, losses received my passbooks, Pata passbooks. I don't understand how third parties can do this.
You file implead
Because
application. Please file implead application. I will grant status quo. Revenue entry till next date of hearing.
Page 140.
Order is already order is the 168, page 168 already.
They have violated.
Page 140.
Initiated contempt proceedings.
Because since I have to take cognizance of this order, please learn it, count.
I want to get your lordship to say that the violation of the order, passbooks are issued. Already passbooks are issued. Today is sent.
I said status quo as on today.
But if there is a violation,
One minute.
are admitting a violation, or if they are saying it.
Passbooks are issued.
Passbooks are already issued. Today, if they are produced, they will say, after passing your lordship's order, passbooks are issued. That's why I want to
make one submit.
Let me record Leonard Senior Counsel statement.
Then will the lordship receive without notice to the person who is a petitioner.
Mr. Avinash, let us find out what is their claim and when Rangarao's name is there.
Yes.
When it was deleted, let us find out. They will come up with their claim. Today I have to record their statement because they are saying passbooks are issued.
Let petitioner's name not be deleted in terms of the order.
Give me that. Or give the names. So I will say status quo with regard to revenue entries.
This appears to be.
Most probably, I do not know how much time it will take for correction of revenue entries because now Tahsildar and the registrar is the same authority. I will record their statement, but status quo with regard to entries will be continued. That will protect both.
Yes.
I ignore this today.
But I do not know what that is. It is not on record. They are not party. When some third party comes and hands over a paper to this court. One will read to no affidavit, nothing on record.
See, when an application is filed before a revenue forum,
Yes.
some third party, who is third party? He is the third party.
Yes, sir. Then section 5 section 5 not requires notices to be issued to me. My name is in the.
That will be decided on merits today. You want any-
Without saying that any person's name is there.
See, since they appeared, they want to file
No
complete
affidavit.
application.
I do not know whether it is what this document is. It's a photocopy handed over by a private party in a court who is not a respondent before this court.
It's a public law remedy. Let us not go by procedure under CPC. If that is to be done, then all the court should say, come on, please don't entertain any application.
I take the.
I have never appeared without filing complete
The
application.
worst case scenario. No, I'm saying document. I'm not talking about appearance. That your lordships have recorded that is, I'm talking about reliance on a document, which.
I am not relying on this, I am just recording their statement.
But I will make one submission and leave it your lordship. In violation of the order, they are saying if this is done, contempt can be filed. But any violation of the order, if they themselves are saying contempt can be filed, but it is a void action. Was number one. Number two, order is from 2004. Number two, admittedly, no, nothing has been.
Such adjudication cannot be done at the interlock. Hearing, that we coming for admission.
Therefore,
Here on merits, I may agree with your contention.
I'm only saying, that the lordships may state that the petitioner's name will not be removed from the revenue record, because otherwise they will take advantage of the status quo. By recording the same passbooks is issued, status quo means the name is already changed. Because changing of name is thumb impression today. If the officer is sitting there and doing this already, all they have to do is put a thumb impression. That is what is happening. Morning somebody's name, evening somebody's name in the same record is happening every day. We are seeing this. If your lordships record status quo, they will say the passbook is already issued, it was already done. And this is the problem what they are doing everywhere. That is what your lordships have seen in the Romara state matter also. That is all I am asking. Order may say the petitioner's name, which shows on page 23-24, that is not be removed. Shall not be deleted. That is the other lordships may see what they are saying. Now we have to see what they are saying. That means they are saying it's already deleted, means it should not be removed.
Passbooks are issued to me.
Now the cat is on the bag. This is what they want to argue. This is what they want to argue. Without notice to the patadar whose name is on record, they will just change the record by thumb impressions and say it is done. Lord, as they wait a complete. Before this,
So all I am saying is already done.
contradict the order.
That may be notice, that's all I am saying. Because tomorrow they will say, why don't you
Have to be changed in the revenue records, which is evident on the face of it.
I submission is already done.
So,
That is called a
any first level.
Give it to the court.
But tomorrow the senior government said, finally, contact, we're not saying that, we're not taking it.
167.
But I'm only saying that, we're not.
167. Lordship, if any,
On the extent of hearing, I will.
Yes, sir.
how can take over the constitution? Lordship is the respondents 2 to 4, but these are collected also 2 to 4.
Yes.
Item 13, Mr. Jagan.
Sure. These are the grandfather. And other thing, stage enough. Is having a land in the available. 679. One acre 26 foot.
Third part to me.
You also find the pedigree of the family of the petitioners. The unofficial respondents, the grandparents of the first petitioner. So the unofficial respondents, first petitioner, they name.
What is the relationship between you and R5?
You also the first petitioner is the grandfather of Kela. Your second petitioner is the, his father, namely, also the Abdul Jalal is the owner of the property. No, the
First petitioner is grandson.
grandson.
The second petitioner is son.
Son. And you want to witness, it says, one is grandson of the, grandson of the Jalal. I find a pretty clear, was going to see. The names are recorded, but in Kanadi portal, the name of the unofficial respondent father will be recorded. Want to sell the property, page, page 36.
Yes, notice to respond.
Mr. Rahul Bas.
After lapse of 30 years, there is a tendency of to restrictions to clear this paper exam. Factual answer, the court has to decide. Claim of the respondents, your also, yeah, the land is the pattern.
How can I suspend or set aside the notice?
How
can I set aside the order? You are challenging that order also.
Yes. After lapse of 30 years.
PCR ready and I.
Latest policy is also given.
But it is stated only by issuing all concerned parties we ever settled law or without issuing any notice to the affected party and also investigate person. Such a was 1 to 20 so on the file of RTO 1 person is attended. For assessment and certificated presented one favor of responsible and it is committed revenue interest and health certificate and matter is remitted back to the RTO for fresh consideration to decide the nature of plans. Whether it is inam or fata is the inam for attractive hours, which is for all interest.
Yeah, this is pending. On same subject property, again, the responsible for issued this.
Technical points, the notice is not issued to the LRs of the inamdars or persons in possession of the property. How can I suspend it? You have contested the case after 10 months you are coming to the court.
And they trusted to file the counsel.
But since it is 10 months, because notice I cannot suspend, I will hear the notice to respondent. Mr. Bhaskar, it is a remand order. So far, no adverse orders have been passed. 1954-55 Kasra Pani, it is recorded Patta. Now he is having a doubt whether it is Inam land or not. Anyhow, he went on technical grounds. He said neither Inamdars or persons in possession nor legal heirs have been issued notice. On what ground I will interfere? He has remanded it. If he has reversed it, I would have granted interim order.
After lapse of 30 years.
If the land is not Inam land, whether it is 10 years or 50 years, is that Inam Patta valid? Was he valid? Forget about it. Forget about 10 years or 20 years. Well, if it is not an Inam land, can he grant ORC under section 10 of Subrogation Act? He 1954-55 it is recorded as Patta. In Patta land, why will he grant ORC?
Number 4 did not give any opportunity.
Unfortunately, lawyers might have advised, I am assuming. Since there was difficulty for these persons in possession, they wanted some ownership certificate, either 38E or ORC. Once ORC is issued, it is very easy to get Patta certificate. So he went by backdoor method, applied for ORC. When the land is Patta, and it is not Patta, I am going by the findings of notice. That there is one council by name Rapol Bhaskar about 10 months back. Why did they know after 10 months?
Issuing of the notice by the respondent number 4.
The court has to look into the delay aspect also. We cannot grant. Today there is no danger to you.
I see the page number 24. The respondent number 4 has been issued the notice to me on 21/10/2023. Then I came to know about the past.
I have seen it. Your clients are parties to section 24 appeal. So how can you say January order was not known to you? You are party. You are saying in October I received notice of fresh inquiry under section 10. Then only I came to know. What did you do for last 10 months? Let them come.
Item 15, Mr. Sridhar Babu.
You have e-passbook
Yes, sir.
where total extent covered.
2 years.
Then why will they interfere when you have e-passbook?
Yes, sure. Both manager and each of the first.
Why there is a difference of 10 guntas? Why are you asking for more extent?
Yes, sir. The first peacefully is the father you must. The remaining property is the ex of the.
First clarify, your patta is for 2.2050.
Yes, sir.
Why are you asking relief for 2.35?
By then, there is no partition. Subsequently, the petition given to Dr. Siv. The page number.
Why the extent is more?
Yes, sir. During survey, it is reduced into like this. The earlier manual passbook.
Then you should go by the survey report. Why are you asking interim order for more extent, though the extent variation is very small. Now, nowadays 10 guntas also is, we have to treat it as a big extent.
In a digital passbook, it is corrected, Your Lordship. Digital passbook, I am relying upon. As per digital passbook.
I will grant interim order, but should I grant for 2.20 or 2.35?
2.3.
Why?
2.3. Because the digital passbooks are tallying, Your Lordship. Digital passbooks are tallying, Your Lordship.
I am seeing your digital passbook. How where it is page 22.
Yes, Your Lordship.
Give me the breakup.
Yes, Your Lordship.
Give me the breakup of survey numbers.
Yes, Your Lordship.
4,
Page number 31.
5 guntas, yes. Number 1 is Kaling.
5.
Number 2, 1 acre 12 guntas. 1 acre 12 guntas 866. That is BCD. 20 guntas.
Number 4, I mentioned, Your Lordship.
703. 703 is not there.
There's 2 survey numbers, Your Lordship.
You have 2 passbooks.
No.
Why the survey numbers are not telling?
Same revenue village, Your Lordship. Same revenue. Actual revenue is 66 and 700, Your Lordship. Para number 4, I have clearly mentioned, Your Lordship. How do you do that? Page of same standing body graph, Your Lordship. 75, 76. 76, body graph, standing body.
Why for 866 by E1 there is no pata passbook?
Correct digital passbook is there.
Go to page 22, compare it with paragraph 4. It's not telling. Yes, it is there in daughters. She is daughter.
Daughter's name, Your Lordship.
Anita is daughter.
Yes, Your Lordship. That's looking at the person. 4 dots.
He has stated in para 5. Why don't you say that these lands are jointly owned by you and your daughter?
Because he is about 75 years.
So in the here, yes, you have stated. Para 5 he has stated.
Yes, so by 9, my lord, he has made a schedule, my lord. But my lord, petitioner only one petition has come.
His father,
Yes, and then also mentioned, Your Lordship.
all are contiguous lands.
That is also mentioned in my first paragraph.
The petitioner and his daughters, 4 daughters.
Yes, Your Lordship. Daughter itself, I mentioned.
Are issued pata passbooks in respect of.
I got that.
Does it come?
The grievance of the petition that the representation dated 30th January is not considered so far to reflect appreciation. Originally, the property is now to.
Page number. What any application?
No mountain national.
They are not taking the online application because there is no particular survey number to this extent. So in an identical circumstances, this court has passed orders.
No, today, long back and during COVID time, situation was different. Now when all the applications are being filed, why can't you file?
Because that particular survey number, that extent is not shown in the.
Give me screenshot. rejecting your application, then I will direct them to
That's
that.
not rejected, Lord. I gave a manual representation, which is a straight.
Show me proof that you are not able to upload online application, then I will grant order. Because now they are saying they are not entertaining physical applications. Petition.
Item 17, the next law form. Item 18, is there not? Agreed by the actions of the respondent, the fee, the fee the properties which were being present of. Property. And you acquired by, and you acquired them through the district change.
Golconda Fort, Hyderabad. Hope you have not encroached Golconda Fort. Because I know, right and left everywhere encroachments are there.
I mean, also assessed to municipal tax, but I have been paying tax aspect. So my only grievance is that the
And you know what these people say? Do you know? They say that Kuli Qutub Shah dynasty has given them these lands.
my only grievance is let them issue any notice or follow the due process of that is my immediate clearance. So issuing any notice, no, they have the time to evict it.
What is there in the property today?
So the property, house property.
GP 620.
In number 2, item 19. Bhavani Shankar.
People ought to be the interest of the on the made application before the second respondent of the ORC. The during the second respondent was rejected the meet on the ground in 1992 the ORC was granted by the third party is not the successor of the actually the judgment of the Content Honorable Court. Only successor and the court.
When was the ORC issued?
Issued after the year 1992.
I have asked this question to many other lawyers. Is the judgment of full bench applicable retrospectively? See order 47, rule 1 CPC. Change of law. Can it be a ground to review cases which have already closed? Then all the RCs will be cancelled. Hyderabad, everything they will take back. All the inamdars will take back. Narayanguda, Inam property. Mushirabad, Inam property. Everywhere Inam properties. I will give you the list. Everyone will take back. See, I have asked this question. I don't know whether that point was argued before the. I know about the judgment. I am asking about prospective, retrospective application. If that is the case, then thousands of, not thousands, many thousands have to be recalled. Today the case is not pending. After 30 years, you are coming to the court to reopen the case. Read order 47, rule 1. Only prospective pending cases it is applicable, not closed cases.
So I made application prior to the segment, so I kindly see so much.
Your appeal should be live, not application. One person was granted ORC. You should have challenged it in appeal, your appeal should have been pending. Then what you said is correct. Where is the question of filing application when already another person is granted?
Yes, right now on the application is made in September 2022 is pending. Proceeding.
Explanation to order 47 CPC. The fact that decision on a question of law on which the judgment of the court is based has been reversed or modified by subsequent judgment decision of a superior court in any other decision shall not be a ground for review of that judgment.
And these certain still pending requirements and regulations, whether the judgments are.
Your case should be pending. Other cases which are pending, they are lucky. Same Urban Land Ceiling Act, that is reverse. Cases which are closed prior to repeal act, unfortunately disadvantage. Cases which are pending after repeal act, advantage. All are awaited.
And the point without notice in the affected parties simply not present application at the due notice because.
1991,
Without-
without setting aside ORC of the unofficial respondent, how ORC will be granted to you? Without setting aside ORC granted to unofficial respondent, how fresh ORC will be granted to you?
I agree, that's why I'm saying that they ask. In the spot order, that's simply rejected without issue notice and without a party party, whether the SI or the issue or due process of that is. I'm taking application letter considered after due notice to the party, my grievance.
Raja Pasha alias Chinna Pasha, son of Qasim. Why this? Raja Pasha is here. Yes, 1992.
98%. Consider the condition I already here.
How many times I should repeat it? You don't have a live case today. There is no pending case. Nothing. Everything is closed. Just because you go and file a new application, you cannot say my case is pending. If that is the case, because of change of law, for example, in that judgment of Supreme Court of Justice Arun Mishra, based on that, can all the lawyers who lost all the daughters who lost the partition should file new suits? Their claims are decided. You cannot ask that. If the cases suits are pending, that judgment is applicable. If the suits are already dismissed, then they cannot.
The official court may take personal notice because
Yes, personal notice. I don't know. 16. 15.
Yes,
Employment and petitioners so also for construction of double bedrooms without any authority so.
But if I, my love, we appear and submit your lordship for vacates to be heard, I don't want to now stand in a position and take time, because I was not expected.
You have an interim order, you are pressing for vacating.
1 acre of land being put to for 2-bedroom construction. Land is sold in
You want time?
I don't want, I can't say that because I've often said that our vacate should be heard. I don't want to stand in the position of a petitioner and ask for time. If I not want to hear the matter, I will submit, but I was only instructed 2 days. But this.
No, please tell me clearly, you want time?
The state, if they don't want one.
Let it come 1 week.
First of my friends were. 1
No,
week
but
or
the
10
thing
days.
is, everything others are there for vacates also, and we insist for hearing. And
Now when you are for the petitioner, don't have so many inhibitions, otherwise your client's interest will be prejudiced. Just because you have insisted for argument as a vacate petitioner, now as a petitioner, if you do not want to,
Responded, petitioners last time said Diwali, I don't feel like arguing, I don't want to make this court, and the dignity of this court goes down. It's not that issue.
10 days,
forget about it, it is only between us.
I know.
10 days you are also.
We cannot have William Shakespeare's discipline. We are in India and we are in Telangana and Hyderabad. We should also understand our local traits. If we have to, you know, what is the standard of discipline of a cab driver in Singapore? Singapore cab driver.
You also have.
If you
Some date, you know.
which date you want?
23, 23.
23.
In fact, my lords, in this matter, all we were submitting is let the land acquisition proceedings take place. Status quo.
And you have interim order.
Yes.
Sold.
67
is sold. Very good. Briefly.
62.
Item 2122. Mr. Home Law.
Both the restitution lords. I'm ready to argue. Finally, lords. But kindly take up the item 22.
because this is first petition which we filed, item 22. The facts were yeah, I'll argue both the facts. First, I'll argue this
You
matter.
want to refer to papers of item 22.
Item 22 is the first thing, because the first petition which we filed. And but the facts of the case are like this, your Lord. The petitioner and the 1 and 2 are both are husband and wife, your Lord. In fact, the petitioners are the owners of 17.33 acres of land situated in survey number 21. Yellakudur, Kudam village, Yellakudur Mandal, Torur division, Mahbubabad district. And in fact, I filed
Where is your client? You filed implicit petition.
in fact, in the second, the item 21, they are the party.
In item 22, you have asked for direction to response 4 and 5 not to interfere.
Yes, sir. Not so, lot may have kindly come to page 11 here. The pata passbook which is issued to the petitioner, petitioner number 1, page 11. Item 1 here.
Yes.
Survey number 21, 17.33 acres. In fact, he has gifted this property to his wife, which is I filed the sale deed, which is at page 13 here.
Page 13,
Page
gate
13 is the sale deed here. I have gifted the property to petitioner number 2, who is the wife of petitioner number 1. Page 1. In fact, I filed the Ahani also, which can be seen at page 20. That is at page 26 here also. Page 26. I filed the Darling paper also, which can be seen. What you can kindly see, survey number 21, Patadar name, Namula Bhiksham, son of Pomerania.
You are Bhiksham.
Bhiksham, son of Pomerania. Not to make a note of Pomerania also, because in this item 21. Item
Difference of age between husband and wife is 15 years.
because the person is 70 years old. Take the number 1. Maybe at that time there might be so much of difference.
Yeah. So, Dharni. Extent of land.
Son of Pomerania.
Extent of land.
Yeah, what's 17.33 in the Darling, page 26.
17.33. Survey number 21.
In fact, what has happened in your the 4th and 5th respondent, they tried to interfere. Then I gave a representation, which is at page 33, your Lord.
Yes, let us go to the next case.
In fact, yeah.
Nothing more in this case. Let us go to
Yes.
the next case. That is important.
Then an interim order is granted.
This can be closed now.
Yes, sir. Both.
Second case can be closed. Nothing remains in that case.
Yes, we are only
Because third party is here.
Yes, sir. In fact, in the second case, that is item 22, we are only seeking not to interfere. Your Lord. This is the
That can be closed. Why will the official respondents have interest when the private respondent is
That's what I am seeking is allowing of the repetition of item.
GP?
Let them not interfere. except in
Item
accordance
22,
with
is
the
there
law.
any government interest?
What I am seeking is not to interfere except in accordance with law.
Yes, you let him argue. You go through the papers. There is no relief asked.
There is nothing trying to interfere.
Why respondents 4 and 5 will interfere?
In fact, they are given.
No basis for relief. There must be some
In fact, Lordship can kindly say
What
that
was
for
their
the-
claim as appellants?
No, in fact, item 21.
21.
Now, Lordship may kindly see the repetition is filed challenging the order, which is at page 15 here also. Page 15.
The name of your clients is Namula Padma, Namula Naveen.
Yes,
Yeah. What is the relationship?
In fact, what are the
Same family.
Nomula Guttaya. That is the father.
No, I mean,
1 minute, I am asking.
Nomula Guttaya is the father of Tilande first priest and Nomula. Naveen is the son.
Padma is
Wife of Guttaya.
Wife of Guttaya, Padma is, yes, Naveen is son.
Guttaya
Then
is,
Bhiksham,
Bhiksham is below the, Bhiksham is below the, no, Bhiksham is not the family. Bhiksham is.
same family name is there.
No, surname is same. You are the, he is, your father's brother.
Guttaya's,
No, Guttaya father is your Balamalu alias Balraj. Your Komra is his brother. That's why I see. Just Guttaya, one Guttaya is there. He is having 3 sons.
Guttaya, 1 minute. Guttaya has 3 sons. Names?
Hailaya, Komraya, Balamalu alias Balraj.
Kumraya, Balraj.
Balraj. 3 sons. The
Bhiksham is son of Kumraya. Bhiksham is son of Kumraya.
Guttaya is your son of Balraj. Balamalu alias Balraj. Now Guttaya is a Patadar. No, father's name, not father's party name, but he named his father's name to his son. Guttaya is your grandfather to Guttaya. Guttaya got 3 sons. One is
Guttaya has got 3 sons, Hailaya, Kumraya, Balraj.
Balraju, the son is named after Guttaya.
Guttaya, yes. Whether he is grandson or grandfather, this is husband of Padma.
Your husband, father-in-law Balraju, mother-in-law Balraju, grandfather is Guttaya. Where the 17 acres, 33 Guttas in survey number 21 stands in the name of Milord Balaraj, Balamalu alias Bal. After his death, Milord, it was located in the name of Guttaya. Milord Guttaya died, Milord, first can you see Guttaya died on the 19th month 2017. Milord. And not the diet. So 19 1 2017 is an employee.
8 on 19-1.
2017. That is a senior officer in ECIL. After his retirement, he died. That's what I see. After his death, Lord, I find the last week I see the expedition papers. My friend fairly Lord has submitted all the papers. But he filed an application under section 4 of the Arbor Act, claiming succession.
For what extent and who was the previously recorded person?
Previously recorded is Guttaya is a Patadar.
Grandfather Guttaya.
No, he is Guttaya. The grandson also is the Patadar now. Balraju is Patadar.
I have asked you, now this confusion has come before because of grandson, grandfather having same name. So, recorded person is grandson Guttaya or grandfather Guttaya.
No, Balraju is a Patadar from 1956 onwards I tried calling. Balraju is a Patadar.
Succession applied by whom?
Bhiksham file a succession.
I'll make my submission.
Bhiksham file a
Clarify all the doubts here.
Yes. You please wait, we'll get him on.
In fact, the order which is under challenge is at page 15 here also.
You know, these facts after that, just 2 minutes I take. Page 103 last week, repetition. But this is an application is submitted before the Tahsildar.
Yes.
You had no.
Yes, what you said is correct, son of Balraj.
No, 103.
I have seen Bhiksham, Tatagaraina, Nammula Guttaya, Tandri Balraj. Again his son's
Yes, first.
grandfather's name also is Balraj. Again.
No, his father is Milord Komraya. Bhiksham's father is Komraya.
Bhiksham's father is Komraya.
Yes, Komraya, Balamalu, and Hailaya brothers.
Correct.
He is seeking succession in respect of my property.
No. Your property, the confusion is he applied for succession of his grandfather.
Yes, sir.
Claim is grandfather.
Yes, sir. Yes.
Again, great grandfather's name is Balraju. See,
So last week kindly see.
no, it is very clear here, page 103.
Yes, Praveen, for the grandson.
The son of so and so, Vasavi Tatagaraina. Mulagattaya.
Yes. Page 105, that's to please.
03 succession application.
And
105.
page 108, please.
Yeah.
That's what, this is the correction. That page 108. Namula Guttaya, Anna Balaraj. My property. These are succession. Then last time is the bottom.
Was property not divided in 3 equal shares between 3 sons?
But they was not having any property. His grandfather was not having any property. Property standing in the name of Balwal only, like from 1956 onwards. They have Pani, I find property.
I'll make my submission so that everything will be clarified.
Yes, please go ahead.
The order which is a challenge is at page 15 your lordship. In fact, like, once we kindly note 1 point your lordship. The second applicant, Nomula Navi, he has died your lordship. At page 15,
Right.
yes, yes. In fact, he has died before the order is passed. In fact, I will clarify everything. Lordship, and now kindly come to now my read papers, your lordship, page 12, your lordship. Only 4 paras, then I will go to other points.
Page,
Page 12, para 5, your lordship.
internal page.
Yes, yes. Page 12. Para, in fact, the 4 grounds which I made a mention. The second response, that is the collector, even after coming to know that the unofficial respondent 5 and 6 have already filed a suit for declaration of title, correction of entries in the revenue records against the petitioner and official respondent who are arrayed as defendants. And even the district collector is a party to that suit, your lordship.
You are reading which paragraph?
Para 5, your lordship. Page 12.
Show me the internal page, because
That WP number 11759.
second say, page,
Page 12, your lordship. Of my
page numbers are not. You tell me the page number.
Of that,
Affidavit, huh?
Yes,
para. Para the first one. The second respondent, that is the collector, your lordship. Even after coming to know that the unofficial respondent 5 and 6 have already filed a suit for declaration of title and correction of entries in the revenue record against the petitioner and the official respondents who are arrayed as defendants. They are already parties in the suit. In the suit, petitioner's land of 17 acres, 33 units situated in so and so, which is also a subject matter decided by the second respondent in the case number so and so. There is the present order which is under challenge. And the second respondent failed to see that once the matter is in the civil court, the second respondent cannot educate on the same subject matter. Moreover, when the suit is pending and the second respondent himself is a party to the above suit, and there is no orders in favor of the unofficial respondent in the suit, which is clearly evident from the order passed by the second respondent. In fact, Lordship, and I kindly see the second clause. The second respondent failed to see the second appellant, that is the nominal Naveen in the case so and so, decided by the second respondent, has already expired on 20/10/2022, and the order is passed on 4/3/2023 by the second respondent, and the order is passed in the name of a dead person, that is late Nomulla Naveen. In fact, the third ground, the second respondent failed to see that the petitioner who are arraigned as respondents in so and so proceedings, that both the petitioner and unofficial respondent have common ancestors, and such failed to see that there is a matching of names. Nomulla Padma.
Who filed suit?
But
Who is the plaintiff in the suit?
plaintiff in the suit is they filed the suit. The unofficial respondent. In fact, I'll come to the suit of my lord.
Which year? Which year suit was filed?
The 2020 year.
When did he file succession application?
Right.
Prior to suit, pending suit.
If you are to, your lordship want to clarify on that, lordship, and now kindly come to page 55 your lord.
No, let me see the plaint.
55 is the plaintiff, Your Lordship. 55 is the plaintiff. Lordship, can you see the parties first? Page 55. Even the district collector, RDO, Tahsildar, even sub registrar is the party. This is filed by them, Your Lordship. But in fact, now Lordship, now kindly come to page 58, Your Lordship. What they have stated in the affidavit. The name, Your Lordship. That Roman column number 12, Your Lordship. Roman column number 12.
Page
58, the bottom, Roman 12, Your Lordship. I may permitted to read, Your Lordship. It is submitted that the plaintiff number 1 approached the district collector on 19/8/2019. This is the first time they came up before the collector for seeking redressal of their grievance since 4 months, and the district collector Mehbubabad and the RDO Torur and Tahsildar Delakudur was not taken any action for inquiry into the matter and do justice to the plaintiff. The Tahsildar Delakudur found that the suit schedule survey number 21 of Students of belongs to the plaintiff, and the defendant number 1 falsely obtained the Patapal passbook on the scheduled property. But no action was taken by the revenue official despite knowing the fact of the title of the plaintiff and enforcement of defendant number 1. But so far no justice is caused to the plaintiff in spite of several requests made to the revenue official. There is no hope of the plaintiff in getting justice without the aid and assistance of the honorable court. Hence the suit for declaration and declare or treat the gift deed of the defendant number 2 as null and void, and rectification of the revenue recovered and permanent injunction on the suit scheduled property. This is what they are. Dr. Can you see the next page? The relief is this what? Page 60. Roman column number 17. To declare the plaintiffs are owners and possessors of the suit scheduled property, to treat the and declare the gift settlement deed executed by defendant number 1 in favor of 2 white so document number as null and void, to direct respondent defendant number 3 to 5. That is the official response to rectify the entries in the revenue record by entering the names of the plaintiffs as patedar and possessor by deleting the names of defendant number 1 as patedar occupant over the scheduled property. In fact, they have already approached this. In fact, I am filing this the case status of this case here also. We have filed the written statement and the matter is pending before this court. Not may kindly see the case status. I have taken the screenshot of it. In fact, the matter now is posted on 29/1/2024. In fact, now Lordship now kindly come to the.
How are you aggrieved then the rights of the parties will be decided in the suit?
Yes, you know. In fact, what has happened is now they have gone before the collector and they got the orders in their favor. Lordship now kindly come to page 22. He has passed an order to change the revenue.
In a statutory order, you are questioning Lordship kindly see that there was the collector passed a statutory order. You are granting Tahsildar passed a statutory order section 553 granting succession to him. We submitted
Before suit, after suit.
before suit. Before suit. That's 53 in a statutory order. But we submitted representation. We were not issued a notice to our superintendent.
He is raising one valid point. He is saying pending suit, how the Tahsil.
And even
I am not saying there is a bar. As you said, there is a statutory order. Once you prefer.
Not a statutory order. The request is filed for statutory order.
Before that, you have filed suit.
I filed a suit. I will not. Lordship, can you see? 2019 on.
There are several judgments. Judgment of Justice Prakash Rao is there. Simultaneously, parallel inquiry can be conducted. That is different. But in the suit relief, you have asked for cancellation of revenue entries also.
No, I am questioning the Patadar passbook institution name by way of success.
When you ask for cancellation of revenue entries, how did you apply?
I'm only on the issue whether the Tahsildar is justified giving succession to him.
You asked a larger relief in the suit. You are the plaintiff.
The order grade has to go. But whether I succeed in the suit or not, that's a different matter.
1 minute. You please point out in the plaint, did they refer to this Succession granted to Balraj.
In fact, they came up only on Watchman kindly come to the plane, your lordship.
You went to Mr. Prabhakar, your clients have gone to the court saying that wrong entries are there.
My submission also please.
In fact,
You have gone to the court.
only on the first, on 1998, when 2019 only, the first time they filed the.
We are not on merits, we are on parallel inquiry.
I will not press the suit.
Why will you not press the suit?
I will not decide about the other aspect, I will not. Whether it is success or not.
In fact, one more point, your lordship. They file the suit, your lordship. They don't get the order there. Now they come up with a writ petition here, your lordship. Because they don't get order there.
No, as a matter of propriety, if your appeal challenging succession of Balraj was pending earlier to filing of suit, I can understand. You chose to file suit.
Yes, sir.
You did not file appeal. When suit was pending, wherein you have asked for cancellation of gift deed, cancellation of revenue entries, again you file statutory appeal.
That's why kindly see. That's true. Section 5.4 is an intimation to the Tahsildar. 5.3 confirm.
You have invoked effective alternate remedy. So, what is the prejudice which is caused today?
In fact, now they are trying to.
What is the prejudice? Tell me.
In fact, the suit is pending there, and the second respondent who has passed this order is already a party there. That's why I was stated there, even in the plain law.
You tell me today what is the prejudice caused to you because of this mutation of your.
Now, come to page 22, your lord. Page 22 of the order, which is passed. The collector has passed an order to change the entry. That's why kindly come to page 22.
You have interim order now. You have interim order.
Yeah, I have taken the extra.
Mr. Prabhakar Rao, it would be reasonable to continue the status quo with regard to revenue entries. They cannot, because you.
Only 1 minute.
No, you please go to your.
Only 1 minute.
Go to your suit prayer.
No, one minute first. It is 19 or something.
Under section 8 of the old act, read with section 7 of the new act. It is your suit. If I can understand if it is his suit.
Like this one. Page 19 was Page 19 was. Page 19 of the include order. The last paragraph.
Page 19.
Further started, this is contained from the respondent, noble officer. Further started, the written statement.
Actually, it will further stated. Further stated.
Further stated that the respondent, page 3, the secretly pleaded, late Uttaya was the particular right, so that's something during his lifetime, he partitioned the above said land in between his sons, father of Somaraya and Island. Somaraya is his father of Vishnu. And after said oral partition, father of Island have alienated their slaves to Somaraya. And the father of the respondent Bhagwan, such his father became the owner of the entire land. He says, he also submitted that by virtue of the said right, whatever possible, was issued in his name, and that being the said society, the gift of the export, that's the kind of thing. He obtained whatever was on the succession. Now he said he claims that he purchased the property. By virtue of the purchase, he got the whatever was and gifted the property in the name of his son. Last week, I see one zero two application, he submitted the plan of succession. Specific order.
1 minute. Today, in what way this appellate court forum order is causing inconvenience to you?
That's when I finally come to page
Will
20.
you please answer this point? Why should I go into this? In what way this order is coming in your way?
Because here the joint district collector has ordered to change the revenue record.
You have an interim order.
Yes, Guru, I have interim order. But they are saying that they want to.
I am asking you, your succession was set aside by the appellate authority. If this order is allowed to continue, in what way you are put to inconvenience?
They will be changing the revenue record and they will try to occupy the land.
Can you give undertaking pending suit?
I know word of Lord. tomorrow I will withdraw the suit, and tomorrow lordship will decide the case.
I cannot permit you to withdraw suit. Because in suit you have made substantive claim.
Lordship, kindly see.
Just because revenue entries are changed, I cannot prejudice the interest of this person. You, because everything is in your favor, revenue entries change, you cannot simply withdraw. Withdrawal also he can oppose.
Yes, sir. The lordship kindly consider and appropriate action. Not it solely, but whether the statutory order passed by Tahsildar is justified. In your section, that's only that issue before the Honorable. Lordship decide that. Lordship decide that.
No, if both of you agree on direct status quo to be
Lordship decide, one way or other. The reason is, Lord, that for person who is not entitled to have succession, he obtained a fraudulent.
They have
without
stated in the
sufficient.
plaint that they have
On the basis of
moved it from the
he looked at the property in the name of his wife.
In fact, when they themselves they have stated they have no belief on the revenue code. Now they, since they got the order in their favor, now they are speaking things different.
Therefore,
They have gone before the court.
see.
I have clearly stated that they have no belief.
The prices are submitted detailed report to the collector.
And the matter is pending.
You could have obtained injunction in the trial court saying
Because they did
that
not, they are coming.
No. The Tahsildar, the data calculation is submitted.
All the relief is sought.
So the collector stating that fraudulently obtained, Lordship kindly see, 102 onwards.
yes, one, you want to argue on merits?
In fact, only on these 2 points, because one is there is passed on.
Pending suit, one is pending suit.
In fact, they themselves they have come up with the government saying that they have no belief on the revenue code and they have only belief on the civil code. Since the matter is pending since 3 years. Since they did not get the order there, they came up in 2022 and they filed their expedition here. In fact, they have themselves stated that in 2019 they themselves they have gone before the revenue code and they and that was not being pursued. They filed it. Because they get if they had got an order there, then they would not have pursued the case. Because now they have got order in favor before the collector. Now they are saying different.
Now it is a very good lesson for the people who will have the same names in second and third generation. From now onward, they will not give the same name to his grandson or great grandson. I can understand father. Third generation person also is saying, no, this is not the grandfather Gattaya, this is grandson Gattaya.
What made the wisdom father is Pomraya. Pomraya father is Pomraya. But the bottom of it is a Patala. Last time I see my vacant application changed. But I find Panish.
No, you may be having a case.
But last time I see that we are filing a suit, it did not debar me to contest your statutory order. It's a statutory order, Lord.
Is any other point?
In fact, the order is passed on the dead person's name. Lordship may kindly see that also. In fact, they have filed the death certificate also. In fact, the certificate is that
There are 2 persons will not get in
page 147, your lordship. Page 147 is the death certificate which I have filed. Page 147, your lordship. The death certificate of the.
He's admitting. Under order 22 rule 3.
In fact, my only
CPC.
thing is, your lordship, since they themselves, they have gone before the revenue code in
I have
2019.
noted.
And 20 they filed.
What is your ask? You are saying it is a statutory remedy, and there is no bar for parallel
Yes. The statutory order, I'm sorry.
remedy.
Last week I see the order passed by the
Yes.
Page 107.
Simple matter, I'll pass on. Why you want to argue? What is there for argument?
And Commissioner also says here,
I'll go through the record, it's only technical point involved.
not slowly, but I just want, what are your planning? The book is never to a patana. Book is never to a patana, below.
Page.
Page 58. Page చేశారు కానీ నమ్ములో బాలములు తన బుక్
Page 58 of
లైవ్ క్రికెట్ అందులో బాలములు సన్న బుక్ 20. Page 110. Death of the Balaman. Content, just show you. I'm not very large.
110.
110. November 21. Number of repairs and of Balaman. That is being the husband or first petition, wicket applicant. Very only 3 points and regular 2009-10 onwards to that it's clear the name of Paris continues. Last week I see 19/1/2017 he expires. The family of Uttaya and his wife and son and daughter resides in Hyderabad because he worked in ECL and senior office. I find copy of the university death certificate. The last week I see university death certificate, page 34. He died on 19/1/2017. Page 35 last month. 35. His date of birth last month. Date of birth is 8/10/1949. When he was a minor, his father was Patala. Then last week pleased to see he obtained your family member certificate to Tehsildar. Page 39. Page 39. He played fraud without that cannot be. Page 39 is the report given to the Tehsildar submitted report to the collector. Page 41 is just. Page 41. How will you not get? When he was in Hyderabad, he submitted application in the month of October without notice to the petition existing Patala as required in the provision of the Star of the Contract notification. Page 41. The village revenue officer submitted of additional rice format mentioning the name of for its information. The report it was mentioned. Nobody Gupta died on 10/7/2002. Nobody Gupta died 2007/2002. Whereas as per the death certificate of Nobody Gupta died on 19/2020, and there are no signatures of Bandi Narsaya, Bandi Ubaya, only 2% signed. Further, from the notepad, it is evident that it's clearly mentioned that no the distance only legal to no the Gutaya. That's not correct. And Bala.
Yes.
That only 2 points.
Answer about this report. It is adverse to you.
In fact, your lordship, can you see they are trying to take advantage of my own papers against her. Lordship, now kindly come to my read paper.
Why can't they take advantage of your own papers?
Lordship, now kindly come to page 140, your lordship, of my read paper.
You should only take advantage.
Lordship, kindly come to page 140 of the read paper, this petition. I filed the, of this Comrai, the proof. In fact, page 140 is the elections commission.
Any interim order passed in suit?
There is no interim order pending. In fact, the matter is pending. In fact, Lordship, I kindly come to page 140, and again I have filed it 142.
So, Mr. Prabhakar, no, please. Mr. Prabhakar is saying now he will advise his client to withdraw the suit. So, if this really.
Lordship, kindly decide this thing.
So if I decide this case in your favor, you will advise your client to withdraw the suit.
I'm not afraid of the withdrawing. Lordship, fraud has been played and obtained.
No, what will your client get? Just because revenue, you are claiming to be in possession of the property.
Possession of the property.
You are not interested in pursuing the suit.
There are person suit also. The fraud will I want to bring to your lordship fraud played by them when they were in Hyderabad. There are Pandurangam case says there are notices to.
What is
the proof to your lordship? Page 140, your lordship. Komara son of Guttaya. In fact, this Komara is none other than the petitioner.
There is no
Page 140 or 2, your lordship.
I submitted your lordship. Komara father is Guttaya.
In fact, page 141, 140.
Patla stands in the name of Balaman, not
Page 141 also, lordship, may kindly see. Namola Komara son of Guttaya.
That Guttaya might have thought, even when I go to heaven, people should remember me again and fight for my property, my son, grandson and great grandson. He might have wished, it might have been his last wish before death. After I die, my family members should fight for my property by taking my name.
He has no.
So how many times you are taking Guttaya's name? He will be very happy in heaven.
In fact, your lordship, only on the main thing is your lordship, only on 2 points, your lordship. One is, they already sought all the reliefs and they themselves they have stated in the plain that they have no relief for the revenue court. And since they didn't get the order, they have gone before the revenue, they got the order, now they are speaking something different. In fact, the person is even on the dead person name, the order.
First case I dispose of. I don't think government has got any interest.
Only one small.
Page 78.
So they have filed the tax receipt here. This is of 96 to 97, 78 years. 78, then 80, then 82. These are dating from 93, 94, 95, 96, which all show that Komrai. Tax, land tax.
Tax can be paid by anyone. Tax can be paid by anyone.
Yes.
Part cannot be perpetuated to this extent. Notice was published. Let's say notice was published. Since the objections were issued and the succession was granted. So you know, contrary cases.
Only one request is in item 22. Let there be direction not to be accepted in accordance.
Government does not have interest in the land. Why should I pass order when they are not having interest? I have recorded his statement.
In fact, the fifth respondent is element upon occupying the land along with the help of fourth responsible. Not to say that except in accordance with the law, let them not.
See the instructions, GP.
Yes, When he is not the owner, we are first of all.
Private party is there, why will the government have interest?
We have even brought to the notice at that time also.
No, we have stated never interfered in the land.
It is sympathetic by.
Item 23, Swarnalata.
Counter. How many? Since it is election period, they want time, Mr.
We are 1968, we have purchased the property, we registered sale. And since 930, we have been owning the property, that is for the past century. So
What is-
only title and everything more, and for the past.
Post on 4/12.
Even it is different, can be granted before this. What is hanging over the head?
Government officials are busy in election duty, they will not come to your land. No one is interested now.
Because thing is that, let's, this will please be granted.
Since he is saying all the departments have been directed by the election commission
About this is the 7th or 8th time it has been.
not to do any duty excepting election duty. They is saying you cannot speak to any officer.
No, it is true, no, that's right, but the thing is that, this is the 7th or 8th time. So we have finally saying the June month.
Sir Ramesh, the first time you have seen election commission has changed so many senior officers, including Commissioner of Police.
But had it been the first time of
Commissioner of Police. So actually during this election notification, they have to go by the directions of the election commission.
It is true.
They won't have
What is, only difficulty is.
last as a
Only
respondent.
That what earlier Madam seen was that. Last study was wrong, Madam, we have stated that to make an amendment.
Was
Madam.
amended. Was amended.
That for that.
Item 24, Commissioner.
4/12. I did adjourn.
Commissioner.
Petitioners are directed to impeach parties who have rival claims over the subject property by next date of hearing. Is he interested? So
Item 26, Mr. Ravinder.
Next week. They will take the history.
request or not? Questions?
Item 27, Mr. D. Ramakrishna.
Dispose of my land application. Inside is also there.
R6.
Dispose of application and no authorization. Then application report there, third notification paid. And the due process are planning.
Item 28, the Moinamma card.
I'll count it. Including this land also?
10 acre 19.
Where do you say this land now of the petition is also? Is represented by Leonard. But there should be clarity whether these 2 acres belonging to the petitioner is included in 9 acres, because survey number 27 is a huge extent. I'll do one thing. In view of the Right. Or you say you will pursue alternate remedy. Let it be withdrawn then. Withdrawn with the liberty to, I am not dismissing it. You want it to be closed.
Close.
Item 29. For it.
The petition is filed, considering that the respondent will not incorporate the name of the petitioner in the unit card. I consider that we follow section 2022. The earning total land in survey number 776-778/1.
One minute. Adish Babu, are you serious in contesting the case?
As far as the formula, it is a bona fide purchase. Whereas initially what happened, the suit was decreed in favor of my vendor. The suit, which is pending before the trial court, was disposed in my favor, in my vendor's favor. And subsequently, I purchased the property. Not that. Subsequently, what happened, accrued by that order, the petitioner before your last filed an appeal before the lower district court.
You and petitioner were party in a suit?
My vendor is a party. My vendor is a party.
I'll counter.
My vendor is a party. Not vendor. The appeal suit is pending before the district court, which is finally listed on 29th of this month, 29th November 2023 for a final
suit filed for?
Suit filed for a specific performance.
After dismissal of suit, he filed the purchase.
And petitioner is? What is petitioner in the suit?
This petitioner, particular respondent number 4, is the vendee of the appellant in the appeal suit.
Appellant was defendant or plaintiff?
Defendant was the plaintiff.
Appellant was the plaintiff.
Initially, the suit was decreed in favor of the my vendor.
Plaintiff is the vendor of petitioner.
Plaintiff is my vendor.
Plaintiff is your vendor.
Initially, suit was decreed in my vendor's favor. Subsequently, it was carried forward by the petitioner before the last, before the district court. Again, it was remanded back to the trial court for hearing a fresh matter. Subsequently, it was allowed dismissed matter. The suit was dismissed.
Yes. On remand, it was dismissed.
On remand, it was dismissed, and again, it was carried to an appeal by my vendor. Petitioner not made the appellant as a party before your lordship. And the bona fide purchase. I am not aware of the fact.
After dismissal of the suit, he purchased the property, my lord.
Is a lady,
Suit was dismissed, my lord, on the 17/2/2021. He purchased the property on 19/7/2021, my lord. The suit performance was dismissed. After dismissal, he purchased the property. He filed a petition, my lord, for selling the property third party. That was dismissed, my lord. I filed a copy of the order.
Page 77.
Page 7.
Rajamallu is your vendor.
My vendor. My lord. Here I am looking at it. Initially, the petitioners have not taken any steps for not to alienate the property. Since no action was taken by them, the property was I had purchased. I had the bona fide purchase. This is admitted fact. If there is a embargo upon the alienation of the property, then I would not have purchased the property. Subsequently, the digital passports were issued in my name. Now it is pending before the lower appellate court in the district court. On 29th, it is a final hearing matter. Orders will be passed. Based upon that, that will be adjudicated.
After the dismissal of suit for specific performance, he purchased the property. Suit was dismissed, my lord, on 17/2/2021, my lord. My lord, 19/7/2021, he purchased the property, my lord.
how did your client purchase from the plaintiff in a specific performance?
Miller. That fact is known to me, Miller. I would have entered into that field. They have not taken any initiation, any steps for not to allege the property. Miller. If they kept silent, Miller. As a bona fide purchaser, I have gone through the revenue record.
Your vendor does not have title. No, how did you purchase?
It's not having the title itself. I have purchased, Miller. That my vendor till that time, Miller. If my vendor at that time the Dharne portal is very much there, Miller. If my vendor is not having a title, definitely I would not obtain the title.
Show me your sale deed.
When my sold it was not well, you will ask the kind after the matter, or I will get the find the sale deed. If it's sale deed, and after 9.
When is the appeal coming up for hearing?
29th of this month.
Appeal also there is no sale. Let the application consider he succeeds in the court, my lord, that he gets the property.
And finally,
No, but he is a third party. He is not having any right.
I will decide on that at the request of.
Item 30, 31, 32. Etc.
Yes. I want to know what is the stand up now.
Insofar as the law is concerned, there are 3 decisions of our court. In fact, we found one. There is a case law has been reviewed. You should have to look at it. Paragraph 15. Would you not like me to read it?
What, because on my request, he has come in. I needed his assistance. Because now 3-dimensional claims are made.
But my respectful submission is who makes a claim may not be relevant. Because ultimately the question which your lordship will have to kindly consider is whether it is a private party as survey can be conducted. This is a short question.
So since
Show the answer.
larger issue is involved.
Yes.
And I am coming across several cases of that nature. I wanted assistance.
That of course I cannot say anything. But would you lordship just see the conclusion in paragraph 26 for a minute? But his lordship reviewed the cases. And finally, paragraph 26, this is how it concludes. The second position that attaches to the above discussion is the request for conducting a survey by the tribe person is serviceable and the scheme policy framework put in place on all respects of survey land is legal, valid, and should be binding on the hierarchy of officers, person 67. The commissioner is not exempted from such a mandate. Now, my lord, insofar as Mr. Ravindra, the party which Mr. Ravindra is representing, they themselves made an application for survey in 2021.
Even aligned?
Yes. They have made an application for survey in 2021. And I just one second. I'll show one more thing to your lordship. Please look at their sale deed. The sale deed which they got. But they have filed the sale deed at page number 31 of the counter. Please take the sale deed. Unfortunately, it's a very smudged copy, and the clean copy that they have filed, the crucial paragraph is missing. Subsequent, what I said is subsequently when a copy was handed over, the copy, the one paragraph is missing. Anyway, see where it is. 31, your lordship gets it. Now please come to page 37. Then paragraph 5. Page 37. The paragraph at the foot of the page. My lord has it.
Which paper?
I'm sorry, I think I just made it one error. I'm requesting your lordship to look at the papers file 33549 writ petition. I think I made a mistake when I said counter.
Page 30. 34.
Yes. At 37. The same thing commences at 31. At 37. Paragraph 5. My lord,
Yes.
the vendor shall get the said properties surveyed and the boundaries more particularly demarcated. The plan annexed and the scheduled minutes are subject to finalization by such survey in respect of eastern boundary. Eastern boundary, as indicated by the line marked some alphabets, and the vendor shall at the option of the vending make good such loss of area etc. So the sale deed itself contains a clause that it should be surveyed. Number 1. They make an application for survey in the year 2021. It is not as if they are now going to come and say that no, I mean, the property cannot be surveyed. It is their case that there should be a survey. But I paid in the same book, if you also please looks at the affidavit, paragraph 12. This, of course, I draw your attention earlier. It is submitted with the petitioner filed an application dated 18/11/2021. Before respondent number 3, seeking survey and demarcation of lands for a total extent of 45 acres purchased by the safety dated 1961. Subsequently, a survey has been conducted and the reports were awaited by the petitioner. But what I'm saying is all of us are saying the same thing, but in different language, different tones, different ways. They want a survey. We also want a survey. And the law is that a private party, at the instance of a private party, it can be done.
209/4/21.
Please serve copies at the request of, I'll have it after 2 weeks because he wants 2 weeks time.
This counter is served to petitioners themselves. This is not. Just tag taken by us, what is this?
No, I mean, that is so much that what the learned special committee saying is that the survey which was conducted at our behest is, I do not know. Let me see.
The other explanation would be. I think the more that is general access one.
Perhaps the government style is that the survey was already conducted. And that is the one which is assailed by Mr. Ravindra's claim. I'm saying, please ignore all this.
Actually, counter should have been filed in the.
No, I mean, what I'm saying is, please ignore all this, conduct a survey.
The government should file.
So that will set at rest all these controversies.
All these.
Because the only thing that your lordship will have to decide is whether it's. Because the survey conducted is assayed by Allen.
Let me just take my son. Counter impact is required in WP 33549 of 21. That's it. Actually, papers are not with me. I just heard the number. Yeah. Yes, please make note of it. I'll take a copy.
Mr. Murli, note down.
33549 of 21. I present description. These one from that.
Yes. 24. No, 23rd, I just 24. Immediately after 13. Doesn't have any. So it is only for hearing.
Yes, sir.
There will not be
But,
any.
what do advocates have got to do with it? Except the voting day? We have nothing else to do so far as election is concerned.
Quite a lot of youngsters are absolutely involved in the politics. So two ways about it.
I'm not in the free.
Why not?
I mean, I'm not. It is come up after 2 weeks, you're not getting.
At least on the election results day, from my childhood, I would sit in front.
Thirty-three, 34. Venkateshwar Rao.
This setting of the survey bureau. The page that is read. With a 27373 went to take it first. Petition number 27373.
Even opposing. R7. Notice to R7.
Notice has been issued.
Notice and not yet received. Proof of service not filed.
Proof of service is going to say,
Not filed.
copy.
Pass over, give the SR number.
The second one, another one, the exhibition, the process.
Wait, notice is served, I'll pass order.
Because this is a. You are conducting the survey. So, in 1.5 years, they are not doing it, not, time and again they are giving.
I'll pass order, GP, find out. Service, possible.
Item 35, Mr. M.A.K. Muki.
First tribunal order is in my favor. Again,
Talak, again, you have to be. Responded to.
include petition if I.
Complete petition. Not impleted. What about service of notice to respondents,
All notice.
6 to 11 children?
Notice and not at received, because of this not filed.
Very nice. Yes, our number, one of.
Pass over, get it. I'll pass orders.
Item 36. The Rajshekar Reddy.
Process RC issue. Issues file an RP application seeking the information with regard to land acquisition of certificate person.
Why can't you file land acquisition writ? Why you want information?
We have filed it.
You are land loser?
We are land use.
Then file a writ
So
petition.
that is the, issue is not that much. Here,
Why you want indirect information when you can get direct information?
already there is a scheme with regard to 22 notification methods. We have manufactured the gazettes and all the system is going on. That bid predictions are there. This information is with regard to different other aspects.
You want to know why it is included in 22A?
Not 22 mm, this is totally different.
Requisition for what?
So we are seeking the copies of the gazette register. For the
With
issuance of
regard to
gazette.
land acquisition gazette and notifications of the year 2 so what does that?
I not sure the last occasion, the learned GP has informed that they have already submitted the required information, but we not received. My instructions are very clear, there is no information that has been received from us. Otherwise, we have not filed the first appeal, second appeal, and we should not wait before my lords. If that is so, they can again issue us, because we not received anything.
Madam, I will forwarded the copy to the council. Of your gazette notification containing details of all gazettes so.
What they say is they are giving information is what the essence of the. But we have not received any information, that is the instruction.
Show me your application in form, step, format.
Wait 15 minutes.
You know what is your information? They wanted gazette notification, whether it is 500 pages or 1000 pages, he wants that.
They are ready to pay.
Take charges, collect charges, pay, and you, what is the information you have given, madam? Gazette notification contains 932 pages. If they say how many pages, how are they interested in number of pages? They wanted the gazette notification, entire text. Where did you say enclosed?
Total 932 pages enclosed.
Find out from your client. Give that copy to me.
What they are saying is, they have already dispatched the information, is the essence of the written instruction. So what we are saying is, we have not received instruction. So let them again provide us. What produce will cost, will be cost.
You don't give him that copy. This is an information. There is no secret. Give him, let him read it.
They are saying dispatch on 30/12. After that, we have filed second application, we are before my lordship in the last session. Now they are saying a dispatch in the month of December 2020 itself. They have not received any information. So let them provide us again,
Let
madam.
them find out whether you can give additional copy to him. I'll ask him to pay additional charges. Tomorrow you want after 1 week?
Lordship had disposed of the direction to provide additional, we are ready to pay the charges. Let them provide again the copy, they are saying they have provided.
GP, already they have provided, he is saying he has not received. He will again approach the authorities, you provide it.
We paid receiving fees.
You are saying it is enclosed.
Yes, included and not addressed to the petitioner itself, my lord.
That is the case, you would have filed the second appeal, first appeal, and writ petition. It is in December 2020, they are saying 22. They are not receiving my lordship, that are my clear decision. Let them provide again what is there.
See, why should we go into that controversy of service of notice through postal? Why should we go into
That is the reason I am
give him additional copy? Your client might not have informed you.
No, I have clear instruction. The last occasion itself, Lord GP has informed.
Your client is a truthful person according to you,
Seriously, my lords.
because it shows it is
No,
dispatched.
because if that has been destroyed, my lordship, we would not file second appeal, we would not file writ petition, because that is in December 2020.
So what is the necessity for them to speak false?
The lordship, the district administration of Siddipet is notorious for these issues. We are dealing with them day in and day out. The land acquisition aspect. Sorry to say this, but this is the reality. They are manufacturing the gazettes itself.
Give him additional set. And second information, they are saying it is available in website.
That's what, man. Whatever it is, my lordship, the gazette copies are there.
Details of printing press where all the gazette notification in respect of Siddipet are printed during 2002. You wanted to know the printing press details.
What they are doing, my lordship.
So they are saying Harish Printer Superintendent so and so
There
Karimnagar.
are a lot of issues involved in this, my lordship. What they are doing is they are not publishing this.
Why are you interested in printing press?
No, we have lot.
They will print in Germany. Why are you concerned?
No, my lordship. They have to publish it in the state gazette. They are not publishing in the state gazette. That is the reason we are asking. A lot of intricacies involved in it, my lordship.
I am asking you, why do you want information about who is the printer?
My lordship, it has to be published in the government public printing press, Chinchal-Guda.
Printing also should be in government press.
My lordship, it is a public gazette.
We do not know what secrecy they maintain. There is Official Secrets Act. If they don't have wherewithal, they will get
My lordship, as per
the
the
latest printing machine from Germany. Why are you bothered?
LA Act, that has to be published in the state gazette. That is the issue there.
Gazette
We
is
are not
different.
bothered. They are
We are concerned about printer. You wanted company who has printed this.
the printing press. So that has been published in the state printing, stationery and printing at Chinchal-Guda for government printing.
When there was,
A lot-
see, I do not
a lot
know,
of issues.
exactly I do not know. When demonetization was introduced, when there was new currency, when there was shortage, RBI issued circulars. So that is secret. How it is printed, who printed, whether it is foreign company who has given this contract to print. Why are you concerned?
These are gazettes, my lordship. These are gazettes. They need to land act to that. Is the reason we are interested, we are land users, or else we have no business.
I can understand gazette notification is there or not. Whether they have conducted preliminary inquiry, Gram Sabha, public purpose is involved. These are the 3 points necessary for land acquisition.
No, my lordship.
What more?
The issue there is, what they are doing is antedated gazettes.
Why will government go to the extent of creating fictitious gazette notifications?
On that basis, it's a 22 on which has been stated by this court, my lordship, another bit petition. Antedated. Anyway, my lordship, additional information may be, additional copies may be provided.
It is better for you. You will get it.
Item 37, Udai Kiran Reddy.
Case for the petitioners private pata land that are included in the prescribed properties. So the petitioner submitted
GP.
an application. By applicant the rejected text.
GP. I'll take up other matters along with this. 2:30. Inform the other council. 16. I can have it after 21st, not next week.
With your permission, Lordship.
1 minute. You please collect the date from the court officer, 22nd, 23rd or 24th will come out.
So conditional word because this is.
How can I impose condition on the Advocate General?
10th time or 20th, 15th time or.
This will be the first time in any court condition is imposed on Advocate General.
Not. 128.
Batch at the request of learned standing council for good on Yagna Board. Post on soon. So please collect the date.
Yes.
37 at the request of learned AGP Revenue 77. Now all revenue matters will be adjourned. One is responding to his calls until elections. So I will adjourn all matters. You can take leave. I can also take off. GB. He is saying revenue officers are busy in election duty. 62. Why not today? No, not many matters I have. You will reach. It is, if you want, I'll post it tomorrow.
Empty carpet. Now with the 230 meters. It is the bounce. And you can inform the site. You will inform him now. Already told him, he will make a mention. Again. Keep your right. Non-motion matters. Mr. Krishna Saina.
Standing council, Singareni.
Where is that not? Check the outside spot.
Small extent of land. How can I get interim order?
Page 26. When I show this copy to them, what they say is starting construction.
Since you have compound wall, I pass status quo order. I cannot, I only say status quo because it is acquired for Singareni Gold, part of it is purchased. Yeah, see, how can I grant order against Singareni Gold Risk? Who is saying that any other new company I can understand? Singareni Gold Risk, why will they encroach?
Depend on they want to
What is the total extent of land in S number 110? Wait for better instructions then. If you want a positive order, wait for better instructions. Status quo is better. Submitted by learned AGP. Revenue Yes.
Item 4, Mr. Puri Masudan Reddy.
These are personal property, this can be not be better of the big will not be will not be government will not exclude the data funding from the
Which respondent? Is there a house? Why will they interfere?
Number 11 will not be government itself is exclude data convenience in favor of the better of the petitioner. Registered sale will not under GOV number 59. Number 11 will not data convenience.
Contention of government leader is people who have regularized 1 bit of land are intruding into adjoining government lands.
Housing there will not construct the compound wall housing there as well. The basic property tax is expired. Electricity bill is filed.
And it has become handy for everyone to take services of these precast wall contractors. Midnight they will come and complete the job. 9 out of 10 cases, these precast walls will be there.
Regularizing as per doing with number 589. After petition of purchase of property registered sale. 80. Proper tax is the same of 31.
Additional claims to your purchase of your property.
Page number 9, specially identified cases. Item 110, Mr. Gori.
Which is your case?
On the serious basis, can it be taken up on this term?
126/23.
Outside.
The request of Leonard, special GP.
On level, Praveen Reddy.
This was argued. Page number
10. Dispose of the picture.
directly be at this stage. Present. Based on the detail of copies. As per the latest news, my name is.
Sorry, pass.
Item 112, the CH Sharma. Item 112. By also question exemption order these property. Job practically cannot be followed. Just settings of some government range point side. I have already citation, but it is your balance 7, 8, 9, 7 for 130. And that's not writing. That's the petition not as some of the similar cases. 19 or 16 years that they would say. Burma issued by the incident. Whereby only police and administration officers are decided. Every person is not given to speak. But then the authority. But the issue was clarified.
Para 6 lot. Short question, whether continent to as covered into the content aspect. The notification is it for dates like that trees. The future information may be relied upon this. Providing the limits to the continuous score. Exclusively in the system of the social explanation starting mobilizing this person. One of the mobilization. Notification so far as the criteria may be set up in excess of powers conferred in 4 of the containment as applied to containment. The resident has a part. Previous times of the government policy. Honorable council and the confidence of the government. Please to declare the story if the group the resident to exercise the criminal police with attaining the days. No limit shall be limited to supervise every department as the guidance. And it shall be held to be included in the use of containment schools. But then African extremists there were other notifications by the HCS mission showing that indication of powers for construction or building in authority Judah and application in the containment area. The US document placed before us in this regard is the notification issued by the reserve date for 1890. Notification reads class, the resident must have no building of any kind should be constructed within the course of the match of the limited of 56 kilowatts and tolerance so that the containment may be practically slow and efficient according to the houses and parts which are the previously erected within the cost mile floor was moved. Notwithstanding these, have also been erected in the locality mentioned, and there has been no process of provision by owners. The officials, judges, and residents of these places surrounding containments are therefore informed that no official officials or judges would be allowed anyone to build this jurisdiction within that particular limits of the containment. Then after 4 secondary applicants, that's the reference to this, because this particular notification that excluded the power of is all other job officers and jurisdiction controls and containment board to supervise all kinds of actions. Then the applicant is it's like from the body, such there is a reference. It's notification as a result of an agreement between the response and the pitching body. In government, it not okay. 29/1939, the subject is referred to the general condition of the residential building into the 40 floor from the conservative. The circular states, according to the agreement of 1893 arrived. The Nizam government and the British only retaining of repairs to board and purpose buildings to allocate within the authorized zones from the containment list. No place constructed even if the board limits to the family. Without the construction of containment, you can explain the reference to notification of national government 4 and 1904. The relevant part of the is added that which the limits of the containment in the past, not only the Kansar villages, but also the Sarkakas, and other jagged villages are situated. It is considered necessary that for the future granting of permissions, construed and prepared and under buildings to the containment are shall rest the containment board, containment country, instructs the Kansar, Sarkakas, and jagged officials. But in never comments of HIH, the Nizam orders are hereby issued that no official belong to Kansar, Sarkakas, Haika, other judges shall be competent to grant permissions for the construction of place or to the enlargement of buildings situated in the villages within the park. In future, the granting of permissions like the first of respective continuity applications of officials of the said villages. But this is also clarified that this is even much prior to 1996 farmer records. And then by the next document, which will also be read in this context, is the legislative productivity returns from the 1943 relating to the construction in the quarter mile to the containment area. The material part of it is the following. In accordance with the previous orders contained in the regulatory facilitated letter, the conservation authorities are competent to grant permission construction of new buildings the goal of the business to supply. But from sanitation point of view, the state authorities have attention in the construction and establishment of attire inside the containment areas and also within the compartment school of containment. Hence, it is hereby ordered that no attire or any kind should be in future be constructed or established within the containment areas. Reading the set notification, it is absolutely clear that containment authorities have exercising power to regarding construction the villages within the containment by delegating referable to an express agreement or 1995 referred to specifically in the government circular dated 25 and 1939. It is obvious that these powers were exercised in containment authorities without any delegation by virtue of the notification dated 28 and 1996 relied upon the extensive document relied upon this particular farmer, saying that by virtue of this farmer, containment authorities have no jurisdiction over the regular aspects. The only reasonable difference we may draw is that the powers referred to the agreement of 1890 was untouched by the notification of 1996 and continues to be so exercised. Then the next sentence may be the military governor of Hyderabad dated 23/10/1948. The notification that the military governor of Hyderabad hereby declares that the cantonment of Hyderabad with the administered in accordance with Cantonment Act 1924 has applied to the cantonment. Speaking about cantonment, also 14 Act 1947 and the construction of the cantonment being corporate store administered by the officer commanding the station. We pass the notice here that the military governor was representing himself who was to be and constitute head of the extra Hyderabad government. Notification as such has to be as notification of the local government within the meaning of orders. There is the subsequent to the proceedings as well as the preceding proceedings of 1906 indicates that the content of the exclusive right over the areas which is that within their position. And then that's the kind of established normally the extracted which is the last thing but clear of India. The High Court of Delhi which was subsequent we would also learn the content of this statute. And zero paragraph is used. The paragraph 20 was what that would have said was 8 paragraphs. 18. So the case law of mentioned the case law 19 paragraph 7 quoted in the year 1967 as was Yes, 18. Grant was by way of resolution. Renewal and it came to an end when service used to be ended. The grantor therefore resumed the system of the body is not going the repetition by dispossessed granting. High Court assumed the grantor was not entitled to take recovery function of property. After resuming the granting
For the Supreme Court substance and definitely it has a reference to following words. Ordinarily, where the property was has been granted to the state on condition makes the grant reasonable. After assumption would be the grant who use the court for adoptively and the proceeds on the basis of the grant after state should have reserved to itself the right to issue may after exercising its right to recover physical property without finding a suit. But apart from this aspect of the matter, it is difficult to see how High Court will justify issuing a writ in the present appeal. The inevitable consequence of which would be if the respondent would remain in possession of property until the appellate filed the suit against them. And that, in our opinion, would be justified, unless the question of criteria are determined and it is held that the object must file a suit before the court for respondents to be specific. It appears that receiving the request respondents, High Court failed to appreciate the legal effect of its conclusions. The question of criteria cannot be tried in this proceedings. Once it is held that the question of criteria cannot be determined, it follows that no right can be postulated in favor of the respondent on the basis of which eviction issue in their favor under Article 46. But in paragraph, the tenure after extracting the Supreme Court ratio, and the observations of the court and paragraph 21. Mere physical possession without any claim of right in retain or against the owner confers no right on the possession. The claim of right may be only established. Nevertheless, there must be a claim, however significant may be. If there is no claim of right at all, then the possession is not legal possession. A person who is not a legal possessor, not a legal possession, and cannot claim to have any semblance of right against the true owner, will not be entitled to large possession, take possession against the true owner. The true owner can peacefully recover possession from a bare licensee or a person in physical possession without a claim of right against the owner directly without going into the court of law or invoking the provisions of public themselves. Which matter another operation. If however the person in physical possession without any right resist the taking of possession or create a law and order problem, then the owner would not be justified in having recourse to violence even in the enforcement of his rights. The provisions of Criminal Procedure Code, Section 144, 145, perhaps invoked by either party. Alternatively, the owner may resort to issue or proceeding under public proceedings act, taking of peaceful possession by the owner using just necessary force incidental to the execution of breaking right does not amount to taking law into their context. The legal process on possession in such a case is taken in due course of law, especially when the terms of the grant etc. expressly gives the right of resumption to the grantor. These are the provisions of Government Grants Act 1985 and Section 6(2)(b) of such relief act. The position of the government as the owner of the land against the granting of the government that is better than the position of an ordinary owner against his grantee. A trespasser is not under stability of being with permissive position only as it is well licensed and whose license is not revocable. We are therefore of the view that the possession of the land and houses taken by the government from the petition appellant in due course of law, the petition appellant is not entitled to any remedy against the government either by way of petition or a suit under Section 6 of the Relief Act. The appeal is therefore dismissed because the person is without any order as to pass. But even Aristotle and
So Mohan Agarwal versus Fifth University also on the issue of similar as Lakshmi can issue paragraph 11 page 21. But in this case, you know, the that the 1935 Act was repealed. Thereafter, Section 14 were discovered alert of charges factors before on the charges to the law made under 1833 Act was imposed by Section 65 of the Government of India Act. Continued all the acts provisions of Section 130 of the Government of India Act expressly saying order number this continued to remain in law when Section 321 of the Government of India Act various Government of India Act as per Section 280 therefore saved the existing law by providing notwithstanding the every law this act of the Government of India subject to other provisions of this act all the law immediately before which are party of the IT altered repealed or amended by the Constitution the right. Now regulations contained in Order 175 of 1836 therefore continued to remain law even thereafter. Section 8 of Indian Independence Act 1947 repeals the law contained in the Order 717 we are also including the power under Section 179. So, Section 179. By virtue of Section 179, general decisions prepared. And wherein this particular subject line is known as a duty work that managing interest officer and landlord is to settle government disturbance concerns. Point number 2 last weekend. Here as it was expressly provided in the law of British India and several parts thereof immediately before the appointed date shall, so far as applicable and is the necessary as the adoption of the law of each of the new dimensions and the several parts thereof until made by law of the legislature provide in person and by other legislation other Order number 179 was that an existing law on the date of enforcement of the Constitution of India. 373 Constitution saved all the existing laws by providing notwithstanding the dispute by this constitutional enactment required in Section 395, but subject to the other provisions of the current Constitution, all law enforced the date of India immediately before the enactment of the Constitution can continue in force in the until orders are repealed and amended by the Constitution. That shows that this particular order GTO, the Honorable Order 1979, is in force even the pre-Constitution. And what we can see that next is included, which is then the verification on the TLS. Paragraph 11 to 19. I have not got no clue. That's paragraph 10. Before that, we are Paragraph 9, the 9, the nature of photography is explained not. The other question is whether the land was held by stone throwing. The old land, settlement area. The grants of land in settlement areas, sort of material land, covered by the government general, order of government general, number 179 of the year 1836, known as Bengal Resolution of 1836. Under resolution of the schools of these regulations, the conditions of occupancy of land in containments are laid out. There are no ground will be granted except on the conditions set out therein, and which are to be subscribed by the every grantee as well as by those to whom this grant will be subsequently transferred. The first condition relates to the resumption of the land. The government retains the power of resumption at any time on taking 1 month's notice and paying the value of principal as may have been authorized to be erected. The ground being the every case property of the government and cannot be sold by the grantee. But houses or other properties wherein which will be transferred by one military officer, one military or medical officer to another, without restrictions, except in certain conditions. The ground has been built upon, buildings are not to be disposed of to any person of whatsoever citizen who does not belong to the army until the consent of the officer commanding station shall have been previously obtained under his control. The High Court makes issued order resonate as extract from the book of the law, which may well be reproduced here. Besides association and other subjects, as always loomed large on the federal origin in the question of register necessary accommodation for military officers near the base of their duty. This led to issue from time to time of section 2 information orders by the government of Bengal as residencies between periods from 1789 to 1999. The regulations were mostly of identical nature. They had a twofold object view that of ensuring sufficient accommodation for military officers and that of regulation of the grants of land sites. Some of the regulations are published. These rules are particularly these rules and regulations are orders continue to be in law in force in India even after enforcement of British statutes application of majority rights. That is, regulations and orders, officers not provided in the government quarters are allowed to erect houses in the settlements. For this purpose, grounds were allotted to them with the condition that no right of propriety whatsoever in the ground was conferred on them, and the grounds continued to be the property of the state was receivable at the pleasure of all, giving 1 month's time notice and paying the value of the structure as it have been authorized to be erected. The houses or other properties built on such grounds were allowed to be transferred by one military officer to another without restriction. The civilians those to be transferred only with the prior permission of the officer commanding the station. Last we can note out this last point. In case of one military officer to one officer and military officer to officer, it can be transferred. In case of a private party member, the prior sanction from the military officer commanding the station. With the lapse of time, the civilians were also encouraged to build bungalows in the government lands. The same condition of resumption of the as given a and with the further condition that they may be required to rent or sell the same to any person with the officer. In case of disagreement about the rent or the sale price or the same was to be fixed by the Committee of Corporation, these tributes and the permission to occupy the government land. In the for construction bungalows came to the owners contract. Such permissions were given most of payment of no rent. This involved a large number of bungalows in the settlement which is followed came in the hands of the civilians.
under section 280 of Consultants Act, power was given to the governor general of county. Where to stop carrying out objects of containment and in fact, the rules to provide the manner in which the authority to which application of permission to occupy lands belongs to council. The containment is to be paid. The authority by which the permission may be granted and conditions that are annexed to the grant of any state person. The excess of this power, the containment is state. These rules are amended up to 21/1930 as produced before us. These rules of containment lands are military district officers of containment shall prepare and maintain a general land register of all the land containments in the form described in Schedule 1, and no additional alteration there.
May I once again, all these judgments are judgments in which there factually and actually existed an old grant. GLR. In my case, there is no old grant. Your Lordship sees that when I asked even on the Right to Information Act, they say there is no grant.
That some of the corresponding dictionary, the officer, lower and officials cannot be construed as a authentic information to say that it is not a old grant property. But we placed before the sample procedures a old grant general land register, which clearly postulates that this particular property is considered as is classified as a big old grant, and the landlord is the central government and should have a management of its officer. But even the order of occupancy rights name also very much mentioned there in that, from who the subsequent purchasers claiming right over the property. And the last just I read without any prior sanction from the competent authority, such sales are prohibited, even if such sales are made, which are not binding on the government. And apart from that, as I read, sample code Supreme Court case document, that 226 this issue cannot be decided on. And last one can be reduced paragraph 13 for a moment. Which the case upward present on the Supreme Court, paragraph 13, largest case read before this Honorable Court. Page 27, paragraph 20. In case of Rajasthan versus Gujarat, the Inlet Court examined the regulation contained in Part 6, 1836, regarding grant of land situated in containment areas, and that is that regulations are self-contained provisions describing the manner of grant and the resumption of the land in containment area. And that the petitioners hearing being a mere occupier of the land under such regulation, he was in a position of a licensee, put license under the grant or under the law was recoverable at the pleasure of the licensor. The judgment of the court was approved by this court in India was the Section 2, by judgment and order dated 5th November 1999. So even the judgment was upheld by the Honorable Supreme Court. If the law lays on other to them, now this cannot be misinterpreted saying that this is not applicable to the case. Then last one can be practical for a moment, sir. Case of Chitra Kumari versus India on the issue of assumption of what kind of property. But by relying upon the previous statistics, you can at this point. So, very Because in this case, Lord, of my case, there is two point Lord, clear that clear freehold property. And the ELR entries are not contributed to and not any person who is in position of property. On that aspect, even last week and there is practically last year. We have evidence last year once not bad. We have evidence relating to finding that out of the intervention. But you see the name is partner, and you get now. Okay, by the transport flow, then you ask me any express. If you consider having substance, now it is now. Once it is considered the World Bank document, the responsive part is planning lot. Once the World Bank has This relevant process of application has to show that they could not this be the position and once evident. Court has held that land is the maybe mentioned that even the 3 appeals it has been admitted question that land as the position is not controverted as these parties were to be covered by the regular policy which showed as a one-side property. Therefore, the relying upon the techniques of people in the start. That's what gets not applied. Then something can one judgment about some mistake case because we shouldn't take it right. Take particular. Judgment was passed under subsequent to Master Property. In this case, below the Master Property Society says, it get the standard. When the civil, the revenue records are also parallelly available on a particular property. And revenue records are the precedent for these records claimed by the and in the instant case, the which based has clarified that the deadline is transfer in its own potential value, but there is no parallel record showing that these properties are also executed in state revenue records as a private property. The instant case, there is no such record to show that these properties are the private properties. There are no such revenue record is available for the properties concerned. So therefore, when I am to submission on this aspect here, the process said that page 44 here, in this case, the there is no evidence at all in the state of the category of different property. And on that aspect, the insurance flat as a level or the land is found that there is no evidence at all in the difference department to change the category to be category. The fundamental right of the petition to travel the section 1956 when the president said there was a deeply category.
Please give me the paragraphs. Yes, all the go through it. We will continue, Mr. Venugopal.
Yes.
After 22nd.
I'll submit the order. 2 hours.
Paragraph
First can complete.
Since admission, yes. The day, any admission matters are pending. So I'll, I mean, next week it may not be possible. After 22nd, I'll. In the meantime, you please ask your colleague to mark the, or to just give me the paragraph numbers. It is in.
Even 37 of the same thing, the was corporate statement and this unquote had that DLR as the bench and
Just like this, but he is declaring for the cantonment board. He says that the land is a government of India property. Let the government of India council also come and make a submission. Tomorrow morning, they may not say that we were not heard.
Yeah.
Obliged.
126 was applied. He heard. So he is informed the special.
Next week may not be possible.
It's only they need to report back what action they have taken. It's not urgent for counter.
Mr. Ravindra Reddy, next week may not be possible.
Political matters are coming next week in Supreme Court. So we need to inform the what actions.
Only they need to inform the team. They are not going to argue the matter.
We can take this 1 week.
Item 1. Item 113, 114.
My lords, beg to appear in this case, my lord. My lords, we are pleased to hear this case, my lord, at length. My lord, if you have to recapitulate, my lords may recollect there are 4 villages. Talwal, Rammayagudam, the Kapra and Rammayagudam. My lord, Panchanamas are conducted, my lord, in 3 villages.
Yes, madam. Authored matters. And point.
Instead of 20th, 20th, Monday, May 21st.
Yes.
Right.
Mr. Raghu, the GP, it is informed, is held up in court number 1, so they wanted to know.
But tomorrow, my lord, I'll be physically present, my lord. Your lordship should post it tomorrow. It's only sharp point, my lord. Notices it issued to a dead person covered by your lordship judgment. Not, they have not taken portion. There's no portion Panchanama, 1 village.
Yes.
But certainly covered by your lordship judgment, Harinam judgments also. No notice issued prior to 10-6.
Your online presence is making such a big impact, so physical presence will make much more impact.
No, my lord, greatly obliged, my lord. We love to argue before your lordships, my lord, physically.
Yes, madam. Yourself or AGP. Only GP should argue ULC matters. Only AGP should not argue. Who told you? One day you will become GP. You should, yes, tomorrow.
Obliged, my lord, greatly obliged.
Item 115, Sarang Abdul Putkat.
Application filing. Pertaining to implementation under RGI Act, the issued order is filed by the AP Information Commission.
Now, there is a separate GP. Next case, GP is here. Madam, the 115 is also yours. You have the papers. Collect the papers in the name of GP.
Item 116, Mr. Ramakrishna.
Same.
Item 56, 230 matters, item 56, Mr. P. Damodar Reddy.
Diverting the newly constructed drainage canal into my agriculture partner lands. Put in the whole period of the year sector in the state number. Newly constructed drainage canal directly diverted into my agriculture partner land in 7/4 acres. Page number 70 clearly shows the process. The old drainage canal was flowing in different way
That is on one edge of my land on the southern side. On the other edge of survey number 437 and 305.
Which document you are reading?
Page number 17.
17.
17. Only now. Unit construct drainage canal directly diverted into my agriculture plot land is surrounded by 438 acres. Now, what drainage is the ISO your person? What drainage canal was passing through ground cut of land and in between the land and survey number 430 on its one side and in between the land and survey number 305 and 437 on its north side. Each 2 feet. Then I was trained, I did not train any application. The year 2020 December, when I was not in the village, Your Worship, Nampanchat people included with the respondent who is the husband of the village Nampanchat. Raised the ground cut of land upper level than my land. Then they made my land is lower level and constructed drainage canal up to my land in survey number 430. The ground cut of land.
Up to means from there, where is the drainage?
From village to up to survey number 430. It is admitted fact.
Where is the final entry point for the sewage?
Final entry point is the only 430.
You are saying up to. The drainage has to somehow go and join main
Page number 15.
channel.
Page number 15. Page number 15 I find photograph.
Whether it is stormwater drain or drainage.
Rain water as well as drainage water. Drainage water is diverted. Newly constructed drainage canal diverted into agriculture. My agriculture land. It is admitted that they conducted Panchanama, Your Worship.
And the water is getting stagnated in your land.
My land, I am unable to cultivate my land since more than 3 years. And the helpless lady of 74 years. My only son is working somewhere else.
What did they say in the counter?
They said that the village drainage canal diverted into up to my land. The Panchanama they said.
What did they say in the counter?
Counter, Your Worship. Page number. Page number 4 of R5 counter. Counter filed the similar lines. The R5 and R6 correlate with each other. While the same counter, there is no difference at all. Only they changed the name, Your Worship. And this is page number 4, counter filed the R5, Your Worship. Page number 4, tab number 5. It is suspected that even according to the petition for the last 7 years, the village drainage and rainwater are flowing into the work to the tank. In survey number 436, which is belongs to one in Bali, 60 respondents. It is also subject to the state drainage, then are flowing in between survey number 438, 305, 437, 436 and part of survey number 438 of petition. Here they mentioned one thing wrongly. Old drainage canal was possible in between land, survey number 438, 305, 437 only. 436 is FTL, it's the final point. From my land, the village drainage canal flows into FTL in survey number 436. That is the final point. Now, taking the counter point by R6, Your Worship. Panchanama conducted by the upstairs, Your Worship. And you take the page number 13 of the counter point with the second paragraph, Your Worship. Other point we are back on the submission here. This is the report submitted by the page 13 of counter point.
13, I have village plan.
Counter of R5. On conducted
Date,
page 13.
Page number is not matching. You tell me the date.
Date is
Panchanama date.
Panchanama date is 1/7. 28 to 26, 21. ఈ పరిశీలనలో నూతనంగా నిర్మించిన ముహూర్తాలు అనేది అల్లప ప్రాంతంలో ఉన్న భూమి వైపు వెళ్తున్నది. ఏం నెంబర్
not having this issue. This is also counter of respondent number 5. Why did he file 2 counters?
No. Better of the way, they find additional better of the way.
Page number?
Page number in my material papers.
You refer to page number 13.
13 of R5. Second paragraph.
Yes.
అధికారి ఫిర్యాదుపేటలకు సమర్పించినది ఏమనగా సోల్పూడి పంచాయతీ పరిధిలో రామకండ భూమి ఆక్రమించుకుని కొందరు వ్యక్తులు నిర్మాణం చేపడుతున్నారు అన్న విషయంపై తేదీ 17/21 పంచాయతీ కార్యదర్శి గ్రామోద్యోగ సంవత్సరంలో కె. సన్నాఫ్ సాహిత్య సన్నాఫ్ పిటిషన్ సోల్పూడి గ్రామం ఇచ్చిన ఫిర్యాదు వెంబడి సమర్పించిన ఆయా తహసీల్దార్ గారు సమాచార ప్రకటన ద్వారా ఇచ్చిన లేఖలో ఉన్న కోర్టు సర్వే నెంబర్కి తూర్పుపై మరియు ఈనాటి సర్వే నెంబర్కి ఉత్తర వైపు ఉన్న ఓపెన్ ల్యాండ్ గ్రామకండకు సంబంధించినగా పేర్కొంది. అది ప్రభుత్వం భూమి కాదు. ఇది గ్రామకంఠం ఖాళీ స్థలం. ఈ పాలిస్పరెడ్డికి సంబంధించిన గృహము ఫ్రెండ్స్ సంబంధించిన గ్రామస్తులు తెలియజేయడం జరిగింది. With regard to the occupation of the Gramkandam land by RCC Velasi, the Panchanama clearly shows that he acquired the Gramkandam land and raised a shed thereon, which is besides his house. Just carry on. Okay.
Who is for R6?
R6, William is appearing. Check filing counter, he never appeared. Since already the matter was before your worship Justice Akshay Reddy, when the matter was set for orders, they took time. 2 points your worship. One is the whether they have diverted the revenue construct drainage canal into my land or not. Second question is whether the sixth respondent illegally encroached the Gramkandam land, which is besides his house, and raised a shed thereon. The 2 points are admitted in the counter as well as in Panchanama your worship. When they admitted your worship, on this artificial smile imprisonment allowed. They admitted clearly in the Panchanama also. Your worship, I kindly see, I made it the first your worship. Page number 35 your worship. Third paragraph. ఈ పరిశీలనలో పేజ్ నెంబర్ 35 ఈ పరిశీలనలో నూతనంగా నిర్మించిన భూకాలు అది అల్లప ప్రాంతంలో ఉన్న భూమి వైపు వెళ్తున్నది. ఈ పరిశీలనలో భాగంగా గ్రామస్తులు గత కొన్ని సంవత్సరాల నుండి వర్షపు మురుకాల పుష్పవనం నుండి తదితర పిటిషన్ అయ్యారు. మరియు ఈ బాలస్వరెడ్డి గారి కుంటలోకి వెళ్తున్నారు చెప్పడం జరుగుతుంది. బాలస్వరెడ్డి కుంట మీన్స్ ఎఫ్డిఏ ఇన్ సర్వే నెంబర్ 436. It is the last point. So previously your worship admittedly on the other side of my survey number in 438 and north side of survey number 437 395 of fixed respondent, each 2 feet was going to finally to FTL 436. When they constructed newly drainage canal about in year 2020, in order to save the land of 6th respondent, the Gram Panchayat people in collision with the 6th respondent, with the husband of the village serpent, entirely diverted the entire village newly constructed drainage canal to my land. But they raised the level of the Gramkandam land besides my land on the eastern side and made my land as downwards and directly diverted in the middle of the survey number 438. Another thing we also with regard to occupation of the 400 squares of ground land, page number 40. Page number 40. Second paragraph. This is a Panchanama conducted by the upstairs and the report submitted by the R4 by R4 to R3. తదుపరి ఈ తెలియపాలపై తమకి సమర్పించినది ఏమనగా సోలిపూర్ గ్రామ పంచాయతీ పరిధిలో గ్రామ కండ భూమి ఆక్రమించుకొని కొందరు వ్యక్తులు నిర్మాణం చేపడుతున్నారు అన్న విషయం
GP answer. Page number? You are admitting that drainage canal is diverted, water is going, and now the last point is here. Which para?
ఈ పక్షాలను నూతనంగా నిర్మించినప్పుడు కాలం మీరు పర్యటనలో వైపు వెళ్తారు. ఈ పక్షాలలో భాగంగా గ్రామస్తులు గత కొన్ని సంవత్సరాల నుండి వర్షపు నీరు మురుక కాలువ నీరు పుష్పలకమ్మ పొలం నుండి మరియు ఈ భాస్కర్ రెడ్డి గారి కుటుంబానికి వెళ్తున్నారు అని చెప్పడం జరిగింది. ఈ మురికి కాలువ వెళ్తున్న ఇరువురు రైతులు మాట్లాడగా మురికి కాలువ మొత్తం 8 ఫీట్లు కలదు. రైతు కె పుష్పలకమ్మ మరియు టి భాస్కర్ బాలీశ్వర్ రెడ్డి గారిని గ్రామస్తుల సమీక్షలో 4 ఫీట్ల భూమి మురుకు కాలువ నీటిని పోవడానికి అడగా టి భాస్కర్ రెడ్డి గారు ఒప్పుకున్నారు. కె పుష్పలకమ్మ గారు 2 ఫీట్లు ఇస్తానని చెప్పడం జరిగింది. కావున ఈ సమస్యను మురుకు కాలువ నీరు పోతున్నది ఇద్దరు రైతులు ఒప్పుకుంటేనే సమస్య పరిష్కారం ఉంటుంది. తమరికి సమస్య
You are admitting now she is not interested. Whatever it may be, it is her private land. Earlier, because of some excess sewage water flowing, you wanted some interim arrangement to be made. One person offered 4 feet, she offered 2 feet. Now she is not interested. You have to divert the drainage canal. Why will the filth of other persons also enter into her land?
Without cultivating my land.
It is the responsibility of the Gram Panchayat and local body to make arrangement. Where will you divert it and ultimately it has to go to the main or septic tank, whatever it is. Gram Panchayat or local body has to make some arrangements. Since you do not have any other alternative, because her land is conveniently placed, what you did is you convinced her, other person. Drainage is entering into these fields.
Let them acquire the right and one helping lordship. That's so least damage will come to both parties.
There is provision under sewerage code and this act, forgot the title, and also GHMC Act. Similar provision will be there under Municipalities Act also. When there are floods, you can take interim, you can make interim arrangement. Even if the party is not willing, you can temporarily divert the flood water. Here also, because of overflow of drainage water, you made temporary arrangement. Now she is not interested. What instructions you will get it?
Unless several instructions they got your lordship. I'm back.
You just find out. Now you have to make alternate arrangements. It is a private land. There is not like land acquired without paying compensation for public purpose and for 5 years, 10 years, 20 years, they have not claimed compensation differently. You cannot say he has allowed drainage water to enter his land and he can never object for that for the entire lifetime. It is not like that. It is a private property even today. In village, you don't have drainage system. So ultimately what they do is they divert it. He has to go outside village or ultimately nature will take care. They don't have canal, their open drains are there in the villages. So they go and the only arrangement which is required to be made by the Gram Panchayat local body is to see that it will go out, it doesn't mix in the drinking water or irrigated water. It has to go somewhere else. That arrangement is there in all the villages. You don't have place, you are conveniently, because she is an old lady, you allow drainage water to enter into her land. Whether she admitted or not, it is not like acquiring land. You have diverted it. Today she does not want, it's like a licensee. Some necessity was there, you requested, she agreed. Now she is saying, please divert, you have to divert, that's all.
Nothing is possible. The admitted question of uncut land on either side of the newly constructed drainage canal. As per IT Act given by the higher Tahsildar in page number 16 or 17. On the other side of the newly constructed drainage canal, the land belongs to Gram. Besides Gram Kanal land, the house of
CP Panchayat
is situated.
Where is he? Ask him to come. Pass over. Because you should get instructions.
Some 57. Jagan.
Please. Distance. Close land. 67. Following page 11 for connecting survey. And page 12 notices to the page 30. Over the Tahsildar. Page 11.
Yes. Shivsagar.
This will be
of the train. Why are you opposing?
Their objections are not called. Not.
A simple grievance is when now the connections are reached to this petition may be transferred.
The petition is filed. The action of it's a respondent Sentence should be complete.
Is that high lodge?
2 months I said, because of elections.
Item 66. Recount for the current. But for the card mechanisms. Where the lands are at that moment. Report only the three. And
Where is Srikant? Where is your memo?
report. Tahsildar report.
File this one. Which page? Which paragraph they said as high?
If petition is filed challenging the action of the respondents, including the official respondents. Imposing the cart track between two temples. The cart track which has been existing for 70 years. Temples are in antiquity. The devotees have been in the Shravana Matsam have been utilizing that cart track between the Vishnu temple and the Shiva temple. And they have been exercising their rights of faith in those temples. Now, the fourth respondent.
You want the cart track
to be preserved. My contention is twofold.
You said closing.
Okay. The action of the respondent 2 and 3 not initiating any action against fourth respondent to prevent closure of the cart tracks.
When the federal status is like this.
You want the cart track to be
preserved.
Retained.
Retained. Now, in the meanwhile, now the present situation is that they have closed the cart track by erecting a wall.
How are you disturbed?
I am a devotee of those temples and a resident of that area. That is one aspect. Therefore, your locus is may not be an issue.
Locus is not an issue, but how are you deprived?
Yes, sir. My contention is twofold. One is I put it on the aspect of faith. During the Mass, I wrote in my affidavit that the devotees would pray in these temples by using that cart track. Therefore, the ritual is that I pray to the Vishnu temple and then proceed to pray to the Shiva temple. That is why my contention is that cart track is bigger. That is on the faith matter. But in respect of
Now,
the public,
did you see the report of MRO?
yes, sir.
They are saying there is already an access road.
At 150 feet road. So what happened, you may kindly see, I have filed an objection to the MRO's report also. That affidavit is filed on 1st August 2023. I have raised a couple of objections. This is if it is a car track which is a public road, the GHMC would have to follow the provisions of the GHMC Act by giving a notice to close the car track. It is not for the unofficial respondent to unilaterally provide an alternate road and then say that this is the alternative. The roads, public streets, best with the corporation. Corporation would have to follow the procedure under the GHMC Act. This is one of my primary contentions.
Did they pass any order?
No, my lord. Here the matter is like this, my lord. There are two temples and there is.
Why are you mentioning it? I have not passed any order.
My lord, on the last occasion, the matter cannot be a lordship of the opinion. I'll consider the report and pass orders, my lord. However, my lord, 2 months have elapsed. We are facing difficulty. The reason is, my lord, the petitioner here, along with certain other localites, are creating an issue there where they're not letting me permit with my rightful permissions. Now here the issue is like this, my lord. I've gone ahead for permission of construction of 18 residential towers, my lord. Then at the time of seeking permission,
Car track has become your access road?
no, never, my lord. Then what I did, my lord, and what I did when I went for permission, GHM did not give me permission, pursuant to which I had gifted this land. If your lordship is on the record, they'll get deed of quick settlement.
Which land is car track?
Yes, this exactly
No,
this
not
land was
this
given.
car tax. Some other alternative is gifted.
My lord,
I say this is your alternative, please live with it.
my lords, and in fact filed by the respondent in their
I have filed it along with the
objections, my lords.
objections. Petitioner.
Page number 6, your lordship.
How this order is coming in your way? I have not passed any interim order.
My lords, one moment, your lordship.
Pressing for an interim order because now he's
Page number 12, your lordship may see the sketch. 12 of the respondent's objections to the petition's objections to the respondent, official respondent's report, my lords. In your lordship, you find a good settlement. And be a sketch, my lords.
What is the inconvenience cost to you now?
My lords, I am developing the property. Now, all the petitioner along with the other localites are daily coming and creating a ruckus. They are under the guise of pendency or as if there's an order passed by the honorable court. Now, my lords, the reason is like this. If your lordship may see the objection,
Clear filing of writ is coming in.
let me just finish, my lords. My lords, the respondents, if your lordship, the petitioner, your lordship may see their objections, they have gone ahead and that like many other papers now claiming this to be a land claiming this to be a road that is connecting multiple villages. Look, this road is in existence 70 years ago. Today, pursuant to such globalization and development, my lords, they are still coming and claiming a private property to be a car track, my lords. Hey, having purchased this land at valuable rates, my lords. And this is the prime and this ideal road, my lords. Everybody knows, my lords.
One aspect, the objections itself at page 16.
As it is a gifted, your lordship may consider that and dispose it of.
Page 16 is the temples complaining the interference by the unofficial respondent went to the civil court. They filed a suit for injunction to protect the car track. The status quo order was passed in that civil court. Your lordship will kindly see page 16. Page 16 of the objections.
You go before the concerned endowment department or institution or government.
That.
How can you file writ petition? What is your interest?
I will address that after. before that, Your Lordship, kindly take up my objections to the memo of the.
First you satisfy this court about your locus standi. Why? How can you come to the court?
No, I have already said that I am the devotee of the temple using the cart track. I am also a resident of that area. So, and there, the temple itself went to the civil court and obtained a status quo order with regard to the cart track.
Not the temple, my lord. Let me see, not be made before
Your Lordship, see page 16. I filed the order of the civil court.
How many times you go to the temple every day? How many times? Tell me.
No, during the season, Your Lordship, I am also a resident of that area. I go every day. That is not the issue, Your Lordship.
Other worshippers, devotees like you, let them come to the court. We will examine. Go to the endowment department, local authority. They will decide. How will I decide?
Road is the subject matter which the GHMC would have to
How
address.
will I decide now? You go to the GHMC.
I am not seeking an activity. All I am saying is that the GHMC would have to follow the provisions of the GHMC Act before a closure of a public street. The procedure is prescribed. Your Lordship may inquire from them whether they have followed that procedure. My humble submission is that they have not. And there is a status quo to maintain the cart track as it is in a claim by the temple. Your Lordship will see page,
Where is it?
Page 16. Page 16 of my objections, Your Lordship. My learned friend was pointing out my objections.
My lord, there's a revenue report categorically stating all the facts before your lordship.
Page 16, Your Lordship.
It is never a public road for which there is no reason for the authorities to follow a procedure under the section 450 of the GHMC Act. The private land. Now it is not even the case that the two temples do not have any other access but for this land. They have 150 feet road which is leading to them.
The same respondent, there is a status quo pending, Your Lordship, can you see? All that cart track, pathway, Naksha.
Devasthanam has gone to the court. Why are you coming now?
No, Your Lordship, I am only trying to point out the Devasthanam has gone to the court. The Devasthanam, because my information is that the Devasthanam is not found in the endowment records. So they say that I can't take action.
Yes, upon hearing the learned counsel for the petitioner.
Road could actually, but there exists a road.
Go to the authority.
GHMC is the
When the temple is before the court, how can a devotee come to the court?
Your Lordship, the road user has.
Read my judgment.
Road user.
Now, in the case which I heard, one devotee, two groups, one is devotee group, one is tenants. They are saying at the temple I think in Begum Bazaar, temple wanted to renovate, government sanctioned about 1 crore rupees. Now they are saying that antique and heritage so and so has to be protected. The temple cannot undertake repairs. After all, you are a devotee. When the God is modern, come and pray if you want, if you are interested. Now in your case, why it is blocked? 150 feet road is there. Walk long distance, you will have health benefits. Go there. See, it is a cart track. You are saying you are not one person. I can understand like there is one temple in Hayat Nagar. Same similar dispute was there. There is a chariot. Chariot is there. Over a period of time, what has happened? It became urban property. Layout was same similar situation. That chariot will be operated once in a year, I think, once or twice. Jagannath temples. What they did in that Hayat Nagar temple, the Sarpanch who developed layout, he has left one road. So as to see that there is no inconvenience during these rituals. Villagers objected. Injunction should dismiss. But in the appeal it was reversed. That is different because the chariot rituals are there. Here you are 1% devotee. Or 1 or 10. I am don't compare yourself with that Jagannath.
I'm only saying customary procession is what locals are absent in this method. For locals, I am saying only for the
Walk long distance to reach the temple.
But the procedure and the
When people are going from India to Manasarovar in China, you can't walk half a kilometer extra mile. If you are interested in worshipping God, the path will be created by Himself. God will create the path, and it is there. 150 feet road is there.
one of the objection is that the 150 feet road is leading to the.
I am going by the report. You please go to the appropriate authority. I cannot decide because temple will take care. Most importantly, understand whether it is civil or criminal or endowments. Unlike a civil right, in criminal law, crime is wrong against society. One person may be accused or complainant. Can a third party ask for investigation? Can third party challenge charge sheet? It is a public crime, public wrong. See the latest judgment of Supreme Court. Accused or victim or parties, third party does not have any right. You are a temple is fighting the litigation. You are a devotee, you are 10%. You don't have locus standi because temple will take care, God will take care of Himself. Next.
Since I kindly directed municipality to at least find a counter. They were
712.
Item 69, the P. Damodar Reddy.
This petition challenging the action of the official respondent. We stopping the red bond amount all of a sudden on the first installment of this year onwards. Earlier, they created dispersed the red bond amount till last year.
Any order passed by
There
civil
is no
court?
order, Your Worship. There is no order. Only civil case is pending from the year 2011 onwards.
Yes. Any interim order passed by civil court?
No.
Yes. Hearing for?
Respondent number, unofficial respondent.
All unofficials, unofficial respondent. Try to split the prayer. 2 pages. No, you ask for a positive order.
To disperse the
IA number 1. Yes. by competent court. Within a period of 2 weeks from date of receipt of copy of this.
After this liquidation, earlier, it is never. How do you miss?
No, that is different.
That's different.
Item 84, Mr. Vasant Rayudu.
It's not called me. No?
This is the matter relating to Jawaharnagar, where the ex-husband, where granted land. This particular case, what has happened is, the eviction JCMC newspaper was suspended and then.
Jawaharnagar is a highly disputed area. I'll grant them finally. Finally, 4 weeks time is granted.
In fact, what is happening?
They are saying they are not able to contact the officers, so 7/12 finally.
Item 99. Sri Ramchandra Rao.
91 you mentioned.
91.
Abu Akram has, no, in the lunch hours he has requested for time. When
23rd.
23rd.
Filing.
Status of Inam Appeal number 337 is disposed of. Direct.
Petitioner was actually the owner of the office of Gorak because my survey number 140 page number 7
Notice to respond number 4.
Adapurnama. They filed a counter but in their counter.
Notice and now
Respond number 4, yes. Wakalat is there.
They filed counters in their counter also there is absolutely baseless allegation they made my petitioner purchased 4 acres 20 hectares out of that for 2 acres 30 kuntas they already issued the for the issued the party. But only thing 1 acre 30 kuntas the third respondent has sold the property to my petitioner. Then they transferred that 1 acre 30 to respondent for his wife. Wrongly they entered the name of 1 acre 30 kuntas. So several times my petitioner went to the small office. But wanted even though the submitted application, they have not entered in the 1 acre 30 kuntas in a for the statement. Several times we did it.
There is the council.
They are quite important. I received for publication.
The absence of lawyers, normally I don't pass orders.
Even though they are baseless allegation they made my petitioner purchased from the respondent and 3 4 acre 30 kuntas. Out of that 2 acre 30 kuntas are already reissued, they are already transferred. Not the Dharni portal. Only 1 acre 30 kuntas are not in the Dharni portal. The respondent and 3 is the respondent 4th wife. He has transferred that 1 acre 30 kuntas to wife's name.
Several times the petitioner went to the MRO office, they said, okay, we do, let them drag on the issue, but they never entered.
Can you inform R4 council?
We already issued consent notice, then others after that, they issued counter copy also.
Today, now inform them that what matter is coming up. I will pass orders now.
Then I didn't inform them a lot, but they know that in the last time they came.
You don't want to inform?
That is even.
Normally I don't pass.
After they came to the court, that is not responsibility of the how I came, that is to come to the court. They have to check the history, everything. I'm 64 years, I'm doing all these things.
You are 64 years?
Yes, you are 64.
Looking so young.
Last time also she came a lot. At the time she noted all those things. Last time she given a date for next week to like
Ask your colleague to inform the learned council. I'll pass orders now.
Lord, I don't have a contact under me, Lord. Okay, how do I replace the respondent council? That is not correct, my Lord. My property.
See, these are regular practicing lawyers.
It is responsibility to come to the court. How I came like they should come to the court. Whether I will check in the nation, in the nation, they should come to the court.
How do the lawyer knows that it is 230 mentioned?
How can they file a counter, my Lord? How can they file a counter?
See, out of turn you are asking matter to be taken up.
How?
Have you informed that? Have you informed that 230?
No, I never informed that.
How can they come?
I thought they come to the court. I don't know.
Give information. See, without informing the council, so you cannot mention. I will pass interim order. Even after hearing them, I will pass orders. Any more signal you want? I said I'll pass. It's an innocuous order you wanted. Wait. So from your younger days, you were like this. Now at this age of 62, if you are so strong and energetic, we have to assume what were you when in your 20s and 30s.
Item number 106. Today morning I asked you to discuss it. 106.
106.
Item number 106.
Yes, because you said 62 years, but I don't believe your age. 62 years. Since you are senior citizen, I will take up. 106.
Mr. Lakshmi Manohar. Please, 1 minute.
This is the repetition and brain just the respondent to conduct this survey. I finally a memo USR number 7708 of 2023.
GP. It is pending.
2023.
Latest again.
And I finally resolutions, mutation, having everything.
Disposed.
My lords, I apologize for interrupting the list, my lords. Item number 78 and 79, my lords. Due to a technical glitch, I was not able to log in.
No, these are mentioned matters, madam.
I apologize.
Not going in serious.
106. 106.
I have asked you to implete this lady.
Yes, my lord, I have filed a petition also. I have sent a personal notice to her. I do not know whether there is no response on respondent's side.
Without knowing service, why are you mentioning again?
As per court directions, my lord, I sent it to you. I filed a petition.
Notice.
it's written, half 4.
You have
This file.
acknowledgement?
Yes.
It's fine. Not acknowledgement, acknowledgement is only issue. Should notice to respondent, suppose the respondent. If service is there, I will pass interim order. Let us wait. Await service of notice to proposed respondent number 4. 2311.
Item 101. So, Tulsidas.
GP Forest. Page number?
Last 3 lines.
Yes. Learned AGP Forest, having received written instructions submitted that.
Page number 90.
They have conducted survey, let us wait for the report. Two 2014 report. Huh?
Yes.
What will we do with 2014 report? Half of the forest might have vanished.
Page number 19.
No, this. Are you on merits? Tomorrow. Since we have some administrative. Let it come on 2311. Where is your matter, Mr. Ravindra? Someone made a request for adjournment.
Item 101.
Item 108.
Yes.
Type one is today.
Tomorrow, because I think there is one program. Monday may not be possible. Tomorrow or 23rd. Yes.
Item 118. Sheikh Abdul Khalid.
Subsequently, the bank has noticed the question.
Request of learned AGP.
Yeah, there is a steady.
Finally, 712. Last opportunity for each time is granted. Property, why you want the authorities to conduct inquiry? Then why you want the authority to decide High Court order? I will decide. Ex-serviceman, suppose ex-serviceman land ceiling, and this court holds, It will be easy for you.
Item 122, Hadisrija.
Mr. Sharma, today not possible. So next,
Tomorrow.
next week, next week, 16, 11. As mentioned, yes, next. 120.
Item 123, Mr. Chandrasekhar.
This repetition is filed for the respondent against respondent authorities for not implementing the order of the Honorable High Court in WC number 1863-21, dated 18/8/51, my lord.
GP,
May kindly go on.
1 minute. Tomorrow motion is.
Item 124, Mr. Krupakar. The respondent finance are not conducting the demarcation and it is having
Non-availability of Tippan.
yes, because they are saying non-availability. Because all the other landlords,
GP.
they got
Tomorrow motion is. If any urgent matters are there, just give the numbers. 1 minute, just give the numbers. Listed matters.
Item 76.
Lordships kindly.
62, US.
Because they are trying to alienate the property.
Yes, 9 lakhs.
Item 98, my lord. Tomorrow in the motion list, my lord.
Millard, item number 72 also Millard. Tomorrow Millard. The Lordship heard the matter, posted for orders.
For verification of the notice was served on. Notice served, my lord.
17.
17 which law?
Already there was an order by the No.4 Lordship for conduction of advocate survey. It is in page number 84 here. And when the petition was taken.
Why did you make private respondents party?
It is that you lordship that purchase of the auction property from by way of auction. And now that they are into the possession of the property after being the highest bidder. And it is a dispute your lordship as they are by the school. The school now for the property advocate commissioner was appointed and for advocate commissioner your lordship the court has directed to cut out the bushes for proper demarcation of the property. And that is in page number 84. Property that respondent authorities have instance right to dispose and interfere with the possession of the property. 84 is the order your lordship cumulative portion. Permitted to be. Accordingly, the recent status is above IA. Once advocate is reinterested to the same advocate, he is directed to take assistance of Mandat Survey Boda and also RDO Boda if necessary to execute advocate commission for it. In the meantime, the plaintiff is permitted to remove the bushes. And the plaintiff was trying to remove the bushes, the respondent authorities have given the advocate. All I am seeking them not to interfere and not to dispose.
Shall be in direction to.
Kindly Millard. That's item 49 extension of interim order Millard. Lordship I could not join.
Order granted. 72.
Much obliged.
My lord, item 41, Lordship. My lord, item 41.
All matters which have not reached passed over today, we have a continue to our.
To verify that whether notice served or not.
Have it tomorrow, yes. 62 I have noted, yes, madam.
Tomorrow at 2:30.
And I'll try to, yes. Madam. 9.
And item number 72 also will have this matter tomorrow, Milord.
Yes.
Item number 103.
103. Next.
76, 33, 74, 71, which all your numbers passed to circulated by today.
Yes, I will note. I see that it. 44, 45.
Milord, item 41 tomorrow motion list, Milord, item 41.
70, 71.
Item
71, Milord.
71, Milord.
One by one.
76.
Yes, 77, 70.
Milord, item 72 also, Milord.
72.
Milord, item 41 tomorrow motion list, Milord, 41.
Item 35.
71, Milord.
For his appearance only, the matter was possible.
Yes. See, part heard, post on 2311. Give the numbers. She will work like happy.